5 months back, my lord. Matter relates to
Which year?
my lord, 2022, my lord.
Okay. Give it to the all place for listing. Give it to the court master. He'll have to adjust
My
one
lord,
or 2 days.
my lord.
Will be taken out.
May I speak your lordship? To due apology, your lordship. In item number 14, your lordship, one date is typography mistake. Here I may allowed to correct.
Yes.
Lordship, item 48, your lordship. Sorry, item 74, your lordship. On 26 also it was listed, your lordship, but it could not hurt. And
Item
item 74, your lordship.
74.
Supplementary. So I have bring your lordship for taking up this matter after motion item, your lordship, because
I'll try to take up.
herein, if this matter is not hard on today, your lordship, from tomorrow onwards, the body will dissolve, your lordship, and one-man committee there will be.
Okay. I'll take it up to this. Okay, because I don't have any other matter.
May
I'll take it up to
may I please your lordship, I beg to mention item 71, 72, 70, the supplementary list.
Yes.
Lordship, I on behalf of my senior lordships, matter is very much urgent in nature. Last 2 days it was listed, but the positive time not taken. Today,
I'll try to take it up.
at 2 p.m. lordship.
No, I'm not assuring the time, because then it will be a chaos. I'll try to take it up.
Yes,
Midnight
lordship.
Masters.
Lordship.
71 to
71 to 73. Obliged.
yes.
May for listing of the.
Listing, give it to the court master.
Hello?
Give it to the court master. Tomorrow it may not be listed.
For a listing of the motion tomorrow.
Tomorrow it may not come. It will be day after tomorrow. I have few pattern matters.
Certain degree of urgency, madam. Sabha subcommittee, madam, the board of directors, they have been constituted without giving the mandatory 15-day notice.
Okay.
May I please, Your Lordship. My lord, this is a matter of 2022, my lord. and-
Give all praise for listing to the court master. I'm not taking it up.
May I please, Lordship. Lordship, we have to mention item number 2, 4, and 9. I'm
2, 4, and 9.
I'm mentioning on behalf of Mr. DKJ in his outdoor station, he informed me on the last night, Lordship,
Okay.
that the matter may continue adjourned for 2 weeks, Lordship.
Okay. Adjourned for 2 weeks as prayed for by learned counsel for the petitioner.
2, 4, and 9, Lordship.
2, 4, and 9. Okay.
Deeply obliged.
May I please, Lordship. Lordship, few some by some cases, Lordship, where Lordship, a one-man committee was constituted, Lordship. Your Lordship was pleased to fix it on 26/5/2023, but the matters are not listed in the motion column. Lordship, may I pray, Lordship, that matter will be listed on Wednesday, because the interim order was also.
Give all praise for listening. Give it to the court master. He'll make some
On Wednesday.
adjustment.
One eviction matter, kindly be pleased to allow me to move tomorrow, Miller. Eviction.
What is difficult because I have pattern matters coming up.
Tomorrow is the 7th day, last day, Miller.
Okay.
Deeply blessed.
On last Thursday, I had made a mention, Malad, it was allowed for today, Malad. However, the matter has not come up, Malad. I say, Malad, this matter will be taken up at 2, Malad.
No, not at
Urgency,
all.
Malad, is that the which will be opened at 2, Malad. I had made a mention and it was fixed for today. It has not come in the list, Malad.
Acha. Okay.
With the consent of the petition, I will to mention.
But inform the other side.
I'll inform the government.
With the consent of the petition, I will to it was item number 29, 30, 31, and 32. These are analogous matters, madam. In the state is represented by the AG. He is out of station, madam. If it can be fixed on 27th June, my lord. The petitioner's consolation.
27th is Wednesday. I'm not taking up on 27th. 26th.
27th June is a Tuesday.
27th June.
June.
27th June is a Tuesday according to my calendar.
Tuesday, madam. I'm saying for Tuesday.
No, not on Tuesday. And any other
26th,
motion day.
26th.
26th. Item.
Item 29, 30, 31, and 32. All are analogous matters.
My lord, there are 4 matters listed today. There is one matter that is not listed today, my lord. That is also connected to the same matter is there, my lord. Same include not there. That is WPC 1620 of 2022.
Just write that. 1260. 12.
1620. 2022.
Okay.
All matters are
On the ground that the learned advocate general is out of station. These matters are adjourned today, based on 26/6/2023, along with so and so. Okay.
please.
Wait, my lord, item number 54, the serious hearing matter. The lordship has already heard the matter. Today it was fixed for some clarification if required, my lord.
What is,
Clarification, in fact, I don't require.
my lord.
Those will be added and I'll fix a date for.
Today I will submit the written document. to the court master.
Please, Your Lordship. Lordship may not like to take up item 48 of the daily list.
Item
48,
48.
yes, Lordship.
Okay, yes.
Deep level.
Item 48, list the matter before any other bench without me. Yes, or no.
Deep level.
Okay.
Supplementary cause list item number 64, delivery of orders.
Interim relief is refused at this stage. We should have notice of motion. Some typographical corrections it will be made in some time. We can go through it in fact.
On motion item number 1.
Madam, this is regarding allotment of the land money. Land is one of the petitioner.
Okay, I'm issuing notice at this stage.
Madam,
I'm issuing notice at this stage.
madam.
For
Can
which
we? Relief may be given, madam.
entry we
Wait.
can't give in this matter.
Madam, we have already been allotted the land, madam.
It's okay, but
Only
entry
the
can't be done there.
third party is disturbing us. madam.
Without hearing them, we can't give it. We
Yes.
don't know the status at this moment.
Madam, can I place the order, madam?
Yes, please.
Madam, that page, madam, 32. Annexer 5, madam. It was allotted in the year of.
See, allotment and the and issuance of what you call settlement are two different things.
This
Once
is-
there is an allotment and now the government, what you call this, the authorities of the government wants to do it to the
Even 2003
others.
also, my lord. 2023 also, page 34, another letter has been issued to the circle officer. madam.
It's okay, but not without hearing the government.
Madam, status quo may be maintained, my lord.
Because if the land is not settled, it's only allotted.
My lord, because we have been there, my lord, not we, the
I mean,
petitioner.
I understand, but still,
Petitioner is for the, my lord, the temple, my lord.
no, I understand,
For
but still
for
no.
religious purpose, my lord, and it has been there for centuries. Since
Oh.
11th century, this has been going on, my lord, the Dole Utsav. my lord.
No, it's okay, but still the
I
fact is
should
that
also
allotment of
think
land
about
is a additional notice including prayer for interim relief. But this is MD Chaudhary and counsel for the petitioner. And Mr. M. Chedial and government advocate appearing for
Respond number 2 and 3.
respond number 2 and 3. And Ms. G. Hazarika and standing counsel for respondent number 1. If you are appearing for 4, you will also appear for 5.
I am appearing for 2 and 3, madam.
And then municipal board will be appearing.
Municipal board, madam, notice to go, madam.
Municipal board.
Yes, madam.
Why? Why government can't accept on behalf of municipal board?
They can, my lord. This is a
Madam,
government
in
body,
some
my
cases,
lord.
madam, they have separate, madam, standing council also, madam.
No, it's an organ of the state.
Yes.
Is it not?
It is my election, my lord. This has been.
Sam and Melody, represented by Sam.
No, chairman is not a party, he is a titular head of municipal board.
In
This-
India for executive officer, my lord.
Executive officer, you can appear.
Yes, my lord.
Okay. For 2, 3 and 4, 2, 3 and 5. And this is Hazarika for resolution number 1. If you notice, including notice on the prayer for interim relief returnable on, we give you a short time. Within 3 weeks, do it.
19/6.
19/6/2023. Revisit extra copies of the resolution be served on the Runner State and Departmental Council in course of the day. The petition shall take steps for service of notice on respondent number 4 by registered post with AD as well as by Dusty. Routing the process through the registry of the court and upon service affidavit. List transparency. Next one. As it is projected that the Dole Utsav in the temple
Krishna temple.
is an annual feature which is going on uninterruptedly for several years. The court expects that the respondent number 2 and 4 will file their affidavit in opposition positively on the next date of listing. And obligor produce the relevant records
Records, my lord.
through their respective learned counsel. Yes.
Item number 3.
Well, if you notice, we will have to examine the
I'm already disbursement. Notice may be done.
Mr. H.R. Ahmed, and counsel for the petitioner, and Mr. Sheridan and government advocate appearing for the respondent. All the respondents here are appearing.
This one number 3, 2, 3, 4. My lord. Yeah, it's 2, 3 and 4, my lord.
3 and 4.
I'm paying for one.
And is Hazarika for respondent 1. And this AIIDC,
Standing council.
who is he?
I don't know the name, my lord, but there is a standing council.
Okay, none appears for respondent 5, although they have a standing counsel. Issue notice of motion returnable in 4 weeks. Requisite extra copies of the petition be served on the London State and Department Council appearing for respondent numbers 1 to 5. 1 to 5. The petitioner shall take steps for service of notice on respondent number 6 by registered post with AD. Next paragraph, the pendency of the petition shall not be a bar for the respondent number 3 to examine the claim of the petitioner regarding his purported share in the acquired land. Next paragraph, the petitioner is permitted to produce a certified copy of this order before the respondent number 3. This start of 4 weeks.
5.
Bill. You should notice. Mr. L. Mohan, and counsel for the petitioner. And Mr. Setia, and government advocate appearing for responding numbers.
3, 4, 5, 6, 7, 8, 9 and 10, my lord.
Yes. And this BTC will be there. Just give a name.
P Nayak S.
Achha,
Rafa, my lord.
P Nayak standing counsel for BTC appearing for respondent numbers. Will be for
And
1 and 1.
2,
I also taking notes for one, my lord.
You will be appearing for one also. There will be two. Two and 11. If you notice a motion, because of extra copies. In course of the pendency should not be a bar for the respondent authorities to examine the claim of the petitioner towards unpaid bill for car acquisition.
6,
Please, the lordship, the senior is out of station, kindly pass over the matter for a
Oh, we will not pass it over. Your name
P. Gogoi.
is P. Gogoi and counsel for the petitioner, who is appearing for finance and GST, Mr. Gogoi. Mr. B. Gogoi and it's stand counsel for the respondent numbers 2 and 3. And for Union of India will be appearing. Mr. Pegu is the CGC also. Mr. G. Pegu and CGC appearing for respondent number 1. Next one. You should notice a motion returnable in 4 weeks. Requisite extra copies of the petition is served on the learned CGC and the learned department council in course of the day. Next, the tendency of the repression shall not be a bar for the respondent number 3 to examine the claim of the petitioner regarding non-acceptance of the renewal application in respect of the GST registration, which has been cancelled. Next, the petitioner shall produce a certified copy of this order before the respondent number 3 to bring the order to the notice of the said authority. This after 4 weeks. To take steps.
Yeah.
8,
Okay.
number 7,
It's also a bill,
Yes.
same as 5. Your name?
Yes, Kakoti, my lord, 8 is also similar matter. 7 and 8 item number. Item 8 is also similar.
Oh, okay. 7 and 8 are same. Okay. So 8 is also same. It is also same.
10,
Item number 10, my lord, appear for finding, the senior is election code number 1.
Okay.
High lords.
11,
I'll issue notice
Yes.
at this stage. Or Mr. K.K. Bhatta, and counsel for the petitioner. Will be appearing for respondents.
Nobody is appearing for this. Notice will go.
Okay.
7. Up to 7.
Okay, issue notice of motion returnable in 4 weeks. Requisite extra copies of the the petitioner shall take steps within 2 days for service of notice on the respondents by registered post with ED. For the learned counsel for the petitioner is permitted to correct the postal receipt number from the registry and submit postal track report prior to the next date of listing. Next paragraph. The pendency, it is made clear that pendency of the petition shall not be a bar for the respondent authorities to dispose of the complaint filed by the petitioner. list out of fools.
Well, I think 4 states, 1 week time,
Pardon me,
4 states,
2 days,
1 week.
1 week.
Taking steps to voluminous.
Okay, 1 week. How's your health, Mr. Bhatra?
I'm not keeping well. Actually, he asked me to come. Let's
No,
say
that is good. One must always be active.
Okay.
Mr. Sharma, nothing like a grandson bringing a grandfather here. Correct.
From my side.
I know that. That's right.
Well,
Mayor, please, Lordship. Lordship, in this matter, PWD was supposed to obtain instruction.
Yes, you have instructions. PWD who's appearing? Yeah, SC PWD. Okay, after some time, let me have. You issue notice who's appearing for border police. You have to make an inquiry. It's an unusual case.
Yes.
Who will accept notice for border police?
Superintendent of Police Border, we are.
You'll be accepting.
That is, I think that is the FT. FT Council,
FT,
yes.
SCFT.
Their name are reflected in fact.
No, but you see, because I have to tell them, otherwise this inquiry they will not do.
Yes,
We'll have to communicate.
Pending Council NRC has been reflected here.
Mr. A. Barwat on counsel for the petitioner. And Mr. S. Barwat on the government advocate appealing for respondent numbers
1, 2, 1, 3.
1 and 3. And give the name blank, so and so. Standing us for NRC appealing for respondent numbers 2, 4, 2 and 4. Next paragraph. In this repetition, the petitioner claims that his identity has been pirated by respondent number 5, who has used the same for reading documents of citizenship.
He has not taken my identity, my lord.
Then
He has taken someone else's identity and they have forged those documents to.
it is not your identity.
No, my lord.
Then you have no right to approach the court. You merely have a right to just give a complaint before the police.
Yes, my
Nothing
lord.
more.
That is my limited grievance, my lord.
If
That
they
I have
don't do
submitted
it-
a complaint to them.
If they don't do it, then you'll have to file a complaint as required under the CRPC. You don't have a right to prosecute someone.
My lord, it is not about prosecution, my lord. My limited grievance is that I have made a representation before SP border. He ought to have considered it. It is his discretion whether
No,
to
you see,
accept or.
you see, let us say, everybody starts one after the other questioning citizenship of X,
My lord.
correct?
Yes.
Does he have to respond to every, every complaint?
Well, exactly, my lord, he does not have to necessarily order an investigation. But if someone gives an information to the police, it is his responsibility to look into the matter, at least conduct a preliminary inquiry.
If they
Whether
don't do
it is
it,
any merit into my
if they
allegation.
don't do it, you have CRPC.
My lord,
High Court will not become a prosecuting agency for you.
my lord, this obligation arises under the foreigner tribunal's order. And my lord, that order does not prescribe any appeal against non-consideration or representation. And my lord, nevertheless, the full bench of this High Court has previously held that before raising any reference, the referral authority has to direct an investigation. And only upon satisfaction of the investigation by the referral authority, he has the discretion to refer it to the foreigners tribunal. Therefore, my lord, there are sufficient checks and balances that are prescribed within that order itself for that referral authority to exercise its discretion based on the information that has been revealed in the
No, this
investigation.
person whose identity was stolen,
My lord.
he can appear, he can always prosecute, but why you?
Because my lord, I am a concerned citizen of my country, and he having violated someone else's right has also indirectly violated my right as a citizen. Because unequals cannot be treated equally, my lord. There are certain rights that are reserved for citizens, and he by taking away someone's identity and misrepresenting himself as a citizen and getting his name entered in the final NRC, that is, my lord, is a violation of my right as a citizen. Because he will have access to my limited resources. He'll have voting rights. These are, my lord, very serious consequences that arises. And therefore, my lord,
Which is the document you say is a forged document?
my lord, the NRC legacy data, my lord, at page 25.
You say it's a matter of record. This forged document is a matter of record. How do you say that this is a matter of record? What is the basis to say that it's a matter of record?
My lord, I'm merely trying to show that there is a great inconsistency in the documents that he has represented himself to
No,
be.
you first of all, you could not have downloaded you ought not to have downloaded this what you call private document of that person.
My lord, otherwise the NRC details are available in the website itself. Therefore, these are public
You see,
records.
that's what I say. You see, out of crores of population in the state, why do you target one person, and how did you arrive at that conclusion?
My lord, there are sufficient materials to arrive at the conclusion, my lord. And besides, he is a resident of my village. And when it has come to my knowledge that he might not be a citizen of India, it is my duty to inform the police. And therefore, my lord, it is incumbent upon the police to embark upon a preliminary inquiry whether there is any merit in my allegation. And my lord, the Honorable High Court has in numerous cases said that when the police investigates, it is on behalf of the community. Well, any public law that is elected is for the benefit of the public. And therefore, if a member of a public is aggrieved, it is a duty of the official respondents to look into it. And there are sufficient checks and balances, my lord. It is not the case that based on my complaint, you directly act upon it and directly refer for an opinion of the tribunal. There are various checks and balances, my lord. In fact, there's an important judgment in the GLT, my lord, 2013, volume 1, where a full bench of this court has specifically determined this question as to in what manner the investigation is to be carried out by the instrumentality of the state before making a reference to the tribunal under the provisions of the 1964 order. Therefore, my lord, there are very specific.
Give the citation again.
My lord, the citation is 2013, 1 GLT. (809).
Which paragraph?
My lord, may refer to paragraph 93. Before the start of paragraph 93, my lord, there is a specific issue that was before the Honorable Court, when it had decided how the investigation is to be proceeded. It is put as question D, my lord. In what manner the investigation is to be carried out by the
I won't be able
instrument-
to find like that. You tell me the paragraph.
My lord, paragraph 93.
This foreign is tribunal act. This foreign is laws. Right. Assam act. Assam comparison. Foreign is laws. Where does this say that a third party will have a right to make a complaint and prosecute?
My lord, the order is silent on this matter. However, it shows that there's sufficient checks and balances in the whole investigation procedure before the police can really form an opinion that the alleged person is a foreigner and before making a reference. If my lord looks at para 93, it talks about the right of a fair trial and a fair investigation, where it is said that during the investigation as well as in the trial, the interest of both the parties would have to be balanced, in the sense that no prejudice should be caused to the alleged accused foreigner, as well as the interest of the complainant will have to be looked into. Because if my lord looks at any cognizable offences, the duty is cast upon the normal citizen to inform to the police, and thereafter the police carries the investigation. Therefore, my lord, even in such a case, though the foreigners cases are of a civil nature, my lord. However, my lord, what I'm trying to impress upon here is, my lord, if your lordship looks at the scope of the Foreigners Act, if your lordship looks at section 7, section 6, it casts a duty on the owners of hotels or
Comparisons. Foreigners acts. You have this compilation of that book?
Yes, my lord.
Foreigners tribunal. Yes, which provision you want me to see?
My lord, section 6 of the Foreigners Act. My lord, I'm just trying to read through the scheme of the Foreigners Act, my lord, to show what the act per se
Foreigners
tries.
Act 1946.
Yes, my lord. Section 6.
Yes, obligations of masters of
Masters of
vehicles.
vessels, etc. Then, my lord, we look at the section 7, obligation of hotel keepers and others to furnish particulars. Therefore, my lord, if the scheme of the act is looked into, there are certain categories of citizens on whose an obligation is placed by the act itself to inform the state about the presence of any foreigners, as in when they come and whether they have overstayed. Therefore, my lord, I humbly submit, my lord, that this provisions has to be read edges them generous, to the sense that while the act tries to put certain obligations on certain categories of citizens, it cannot be interpreted in a negative light to say that an average common man is excluded from providing information to the competent authority about the presence of a foreigner. If that
No,
narrow
section 6 and 7 can't mean that every citizen will have a duty to say.
My
You see,
lord,
it's different from the proceedings under the CRPC, where if there's a cognizable offense,
my lord,
then it has to be reported to the police.
my lord.
It's a duty cast.
Yes, my lord.
But you have to show us that the duty in terms of the CRPC is cast here. That every person, because you see that it will be a chaos. Everybody will write against anybody that alleging that he is a foreigner and he is subjected to a investigation by the police.
My lord,
Even a citizens can be harassed like that.
my lord, what I'm trying to impress upon here, my lord, is that the purpose of the Foreigners Act
No.
is that,
See, first of all, if the police has to go,
my lord,
it is the border police. It's not the normal police which goes there. That means to determine the whether he is a foreigner or not, the investigation is not to the normal police. It is to the border police.
my lord.
Number one. Number two, it shows from the scheme of Foreigners Act that being a foreigner is a crime where he can be sentenced.
My lord.
Because if he's a foreigner, he'll be deported. He loses his citizenship.
Well, not necessarily, because there will be certain determinations whether he'll be covered under the clause 6A of the Citizenship Act. If you can prove that he has come before the stipulated date, he will not lose his citizenship, my lord. He'll merely lose his voting rights for 10 years and then he'll come back. Therefore, my lord, if he is able to prove that he is a genuine citizen, then the matter ends there, my lord. What I'm at, my lord, is that if that person has overstayed or has not come by way of a proper mechanism as established under the law, then he cannot stay illegally in India, my lord. That would be a violation of my right as a citizen. And also it might bring threat to the security of the state, which cannot be, my lord, taken lightly. Therefore, my lord, it is an obligation on the investigating authorities to go to that place and investigate. And my lord, it is not a mechanical investigation. In fact, my lord, the Honorable High Court has clearly stated in that judgment that I have cited, my lord, that it cannot be a mechanical investigation. The person has to, the police has to go there. He has to meet the village headman. He has to talk to the neighbors in that village and gather evidence, my lord, to prove that allegation that that person is an illegal immigrant or foreigner. And only upon coming into a satisfaction that that person appears prima facie to be a foreigner.
Who was given this complaint at page 41?
My lord.
Who is given that complaint at page 41?
My lord, this is Jahangir Alam. He's the son of the petitioner, my lord. He is the son of the petitioner, my lord. However, the main complaint that has been placed before the SP border is by the petitioner himself.
Where is that?
My lord, is that the original is at 43, my lord, and the translated copy is at 42. I apologize, my lord, when that complaint is by the son of the petitioner, Jahangir Alam. Nevertheless, my lord, the SP border was informed that there is a presence of a foreigner and that appropriate investigation be conducted. Page 43 is the vernacular, my lord. 42 is the translated copy.
Yes, you're appearing for NRC
For SP border.
or SP border. Yes, what do you have to say?
At present, Lordship, I have to take instruction, Lordship, what is going on there, Lordship. Regarding this, Lordship.
No, where is the complaint before the border police?
My lord, it is at page number 42, my lord, the translated copy.
What is not to border police?
My lord, Superintendent of
This is
Police,
from border.
border Morigaon. 43 is the vernacular, my lord. প্রতি মাননীয় মৰিগাঁও জিলাৰ আৰক্ষী অধীক্ষক সীমান্ত মহোদয়ক সমীপেষু।
No, where is the proof that this was delivered to the police?
My lord, it was delivered by hand, my lord. I did not receive an acknowledgement of that copy, my lord.
Okay, you just you name Mr. A. Barwa for the petitioner and Mr.
G. Sharma,
G. Sharma, then standing also for the
Foreign Tribunal.
Foreign Tribunal, appearing for respondent numbers.
Appealing for respondent number.
Four.
1 and 4, Lordship.
For 1 and 4.
Yes, Lordship.
And state coordinator NRC, you will be there, Miss and Devi, that are standing also for NRC representing respondent number 2. For government, you will appear, Mr. S. Barwa, then a government advocate appearing for respondent number 3. The petitioner alleges that the respondent number 5 is a foreigner and not an Indian citizen. In this regard, the learned counsel for the petitioner places reliance on representations within bracket annexure H collectively. Out of the said representations, a representation dated 38/2022 only is to the only the representation dated 38/2022 is addressed to the Superintendent of Police within bracket border. But the complaint is by the by another person. Mr. The Learned Counsel for the petitioner submits that the complainant is the son of the petitioner. So now there is the acknowledgement is not available. So accordingly, the Learned Counsel for the appearing for respondent number 4 shall obtain instructions as to whether such a complaint within bracket page 43 was received by the said respondent. Next one. District next week, you can get the information. Next week?
2 weeks, next week, Lordship.
We only need the information whether it's received or not.
Next week.
That will see. Give a date after a week. In the motion column.
9/6.
Take your book.
14.
I'm obliged, my lord.
I just try to find out
Yes, sir.
what is the procedure, how they go about in the
Yes,
complaint
Lordship.
by a third party. Correct?
Yes, Lord.
How they deal with that.
My lord.
For the time being, we are not required to take any steps.
Yes.
Only I want the information whether it was received or not.
Yes, Lord.
Yeah.
My Lordship, I am the owner of a land of 25 biga, which is Nyadipata land. The Lordship will find.
I want to issue a notice at this stage.
Yes, Lordship. Yes, they have the DC and Forest Department select to specific order because joint verification has been conducted and Supreme Court judgment has been misquoted, misinterpreted by the DA. Page 50 is the letter, my lord, which I.
No, if you go on merit, then I'll have to dismiss your application. You see, I'll say very simple, that your land is in the periphery of the forest. The forest, in one of the documents says that it is in the middle of the forest.
No, my lord, that is the case, my lord. I know because issue notice, another case is pending along with those, both these matter will come to be right. It needs hearing, my lord.
Yes, yes. That's why I said I'm issuing a notice, but if you are starting,
Because similar judgment Supreme Court.
if you are starting a hearing, then I'm ready to take a hearing also. Heard Mr. V. Sharma and counsel for the petitioners, and Mr. D. Govind and standing counsel for the Forest Department, Ms. G. Hazarika and Government Advocate appearing for the Revenue Department.
I'm attending for it.
For Forest, you will be there.
Forest is-
You will be for?
Revenue department.
So for revenue, you will be there. Okay, not Ms. And Mahanto, PR Mahanto. Correspondent for Forest Department. Yes, so issue notice of motion including notice in the prayer for interim relief returnable on when
Particular date, my lord, got fixed, so that I can fix the another petition. It is 282.
date after 4 weeks.
2002. You know, or unless date is given your lordship, very difficult to get listed today's situation, my lord.
Okay.
19 July.
Requisite extra copy of the petition be served on the United State and Department of Counsel in course of the day. This one, sir.
19/7.
19
for 6 and 7.
along with.
For 6 and 7, okay, Mr. Barba, for 6 and 7.
Let the matter listed along with it, petition number.
No, in motion, I am not listing, admission, I am not listing.
Oh,
What is the case at, that case in what stage?
Same state notice has been issued, my lord.
You make a prayer, we'll get it.
All right.
15.
So Das, this is otherwise an appealable order.
No, my lord, this is either we are to file a review petition or the writ petition, my lord. Because it's a miscellaneous order, my lord, in a miscellaneous petition, that order has been passed, my lord, by the learned district judge, Hailakani, my lord. You know, what interestingly, my lord, on this, after receipt of this, the compensation amount assessed by the district authority, my lord.
No,
without any protest, my lord.
I'll tell you a simple reason, Mr. Das. 226, I am very, what you call, unless I am satisfied against a court, I'll not issue, because you see, a writ will not lie against a court.
Yes.
But it is different insofar as tribunals are concerned.
Not due to the pending cases, my lord, just I'm a position before lordship. In the similar situation, my lord, which is a series of cases are pending before this.
No, that is okay, but you see, writ cannot lie against a court.
Right.
I have not one authority, I have got several authorities, including a constitution bench judgment, which says writ shall not lie against a court of law.
No, it is actually,
Because you see, a judicial officer has a discretion.
Right.
That discretion by issuing a direction of the High Court can't be taken away. I can't issue a mandamus against the court that you do like that.
no, it should, I am challenging the judgment passed by the additional decision.
But why not under 227?
My lord. 227, my lord,
But 226, I have my own reservations.
but there's a pending cases, my lord.
No, that may be, but the issue of jurisdiction was never taken up. It would not lie against a court.
Right.
I can show you that judgment.
That is, this can be converted, my lord, this can be.
No, just be satisfied with what I'm trying to say.
My lord.
It's in fact a special judge, special bench of Supreme Court
Well.
of the quorum was 1, 2, 3, 4, 5, 6, 7, 8, 9 judges.
My constitutional bench, my lord.
Yeah, no, 9 judges, special bench.
Yes,
And you'll see the quorum. Justice, Chief Justice Gajendra Gadkar,
Well.
Justice A.K. Sarkar, Justice K.N. Vanshu, M. Hidayatullah,
well,
Justice J.C. Shah, G.R. Mudholkar,
yeah.
S.M. Sikri, R.S. Bachawat, and J. Ramasamy.
Yes,
All of them
my lord.
stalwarts at their
Yes,
point
yes,
of time.
my lord.
Correct. Yeah, this is the case of Naresh Sridhar Mirjakar,
Right.
67 SC page 1. Yeah, because this is a very long judgment, immediately I can't be able to resort the exact sentence, but in the head note you will find this.
Fact that the full constitutional bench has relied upon the case of Radhesham. So there, the only small little paragraph has been added as to why judicial order cannot be challenged in 226. So this is, may I read the relevant portion? While the above
Just
judgment.
a moment, let me just Mr. Das read this. That in the top I have opened it up. A judicial order can be corrected by revision and appeal. And not by a writ. It's a 9-judge bench. It's somewhere in the middle. I'll not be able to locate immediately, but with some time I can even locate that. But there is a full-fledged paragraph on that.
That's right, that I will get.
So we'll permit you to alter it to 227.
But that can be, we are going to difficulties, my lord.
Okay.
Only actually only similar because when there is a number of cases are pending before this honorable court and similar point, my lord.
It's okay. I'll give my reasons and say that it can be the 227. This is under which act?
Telegraph Act, my lord.
Telegraph Act.
Telegraph Act, my lord. Section 10 and 16, my lord.
It's a land acquisition.
My lord.
Right of way.
Right away. Now, actually drawing up there, my lord, the part, the transmission by high transmission line, my lord, over the transmission
Telegraph Act.
for drawing.
This compensation is determined under which provision, Mr. Das?
But this is my lord. Indian Telegraph Act, my lord. Section 10, my lord.
10. Because here somewhere I remember there's a dispute mechanism by way of arbitration.
Right.
Somewhere it is prescribed in this act.
Right. Now, if a deep person also may say agreed, my lord, by the assessment made by the local authority, the revenue authority, district revenue authority, he can file an application under section 16.
Under 16.
My lord. Of the Telegraph Act, my lord. Before the civil court may additional district judge, my lord.
Okay, Mr. NC Das, then the senior counsel. Assistant Ms. A. Devi, and counsel for the M. Devi, then counsel for the petitioner. The petitioner command being agreed by the determination of compensation for drawing overhead electricity power line,
But the transmission line. man.
electricity transmission line, had approached the Court of Learned District Judge, which place Hailakandi,
Highland.
under the provisions of section 16 of the Telegraph Act, 1885. Full stop. As per the provisions of subsection 5 of section 16 of the said act, every determination of a dispute by a district judge under subsection 3, or subsection within bracket 4 it shall be final. Full stop. Accordingly, the learned senior counsel for the petitioner submits that he has challenged the order passed by the learned additional district judge, right?
Additional district. judge,
Hailakandi,
Hailakandi.
in Miss within bracket PG bracket close number 12 of 2016. Full stop. Next one, it is submitted that several repetitions of similar nature is pending at various stages. Yeah, are pending at various stages. Full stop. Next one. In the prima facie opinion of the court, the Court of District Judge being a court having civil and criminal jurisdiction is not amenable to rate jurisdiction and the said legal proposition has been held in the case of Naresh, Naresh, Sridhar, Shri Dhar, Mirjakar, MIR, MIR AJKAR, Mirajkar, MIRAJ KAR, Mirajkar versus State of Maharashtra and others, AR 1967 SC1, which was decided by a special bench of the Supreme Court of India with a quorum of 9 judges. Therefore, notwithstanding that similar repetitions are pending for adjudication before this court, the court proposes that the petitioner shall correct the cost title of this rate petition to convert it into a revision in Article 227 of the Constitution of India. Which shall be done in the presence of registrar within the judiciary. And consequently, the registrar shall re-register this as a civil division and listed in the motion column as early as possible. We'll send the file to the registrar.
Fine, that's all.
To the registrar.
This time, my lord, at number 16 and 18, my lord.
16 and 18,
18.
same. I'll send it by afternoon.
All right, my lord.
Second half, you can go there, to the registrar.
Seventeen,
Lordship.
Button down your coat. Button up your coat.
Sorry.
Yes, you are appearing for income tax.
Lordship, sorry.
And you'll have to adjudicate and send it for recovery to the IRC.
Lordship.
That is the law.
Lords, I have made one, if my lord permit me, this list of dates, just for your lordship's time convenience. Lords, can have it.
Bankruptcy proceeding has been initiated. IRC has been appointed.
Your lordship, the date of the resolution plan, my lords, approved by the NCLT was 6 March 2020, my lords. First date my lords can have. And after that, my lords, in this peculiar case, the
Yeah,
NCLT,
is IRC appointed or not?
yes, my lords.
They will go there. Adjudication will be made.
My lords, the fact of the matter, which I want to just kindly bring to time notice, lordships, that when the resolution plan was approved by NCLT, then NCLT lordships reversed it. Then the matter went to the Honorable Supreme Court, my lords. And then Supreme Court, your lordship, said that what resolution plan is approved by NCLT is restored. So when these assessment proceedings in the income tax law in 2022, for these 2 years, my lords, assessment year 16, 17 and 11, 12, my lords, 2 years are there. Now, these are prior to the period of my lord's resolution plan. So we cited this Ghanshyam Das Mishra's case, my lords are aware about this 3-judge bench order.
No, there is a latest judgment of Supreme Court 23. I don't have those
I have
citations.
my lords, I've brought it, my lords.
There it has been held that the income tax authorities, being a debt of the state, will
After that, my
adjudicate.
lords, then yes, my lords are, that's rainbow case, my lords, if I'm not
No,
wrong.
no, even after that, after Rainbow also there is a.
There is a Ruchi Soya's case of the 2-judge bench of Justice Datta and Justice Bhatt, my lord. Justice,
I don't remember like that.
well, kindly have my lords item 2, page 74 to 76. That's the latest order I got, my lord. After
Case 70.
4, my lords. I'm so grateful to you, the board.
No, no, not which is after that.
This, my lords, says that something not coming in resolution plan will buy.
Last week, when income tax matter, we take it to court. Last week. Yeah. It was all right. After some time, I have passed an order in one of the matters 2 days back.
Oh,
Just
so
after some time. Not Ruchi Soya. After that, there is another judgment.
I'm not sorry.
Very,
I'm
very
sorry.
recent judgment.
I'm sorry, my lords.
Hmm.
Although I've got this 3, my lords, 3 high courts order, 1 hour Delhi High Court order also, my lords, where Justice
No, no, now Supreme Court has said that the income tax authorities, they will adjudicate it. And it is only the recovery which will be sent to the IRC. They can't execute, but they can determine. Because it's a question of revenue and therefore it has to be determined. Only the recovery will go to the IRC. We'll wait for some, just wait for some time.
My lords.
I'll have to track it out.
19,
Same, my lords, 17 and 19.
Oh, 19.
Same.
Same.
Yes,
Okay.
my lords.
20,
My lord, without going to the record, my
But
only,
High Court cannot direct disconnection of electricity.
no.
It's an essential supply.
I'm not there, Lord. That is why I said that without opening the file also. What is my problem, Lord? My client is the owner of a plot of land. So he entered into an agreement with a person that he will develop the plot and he will give 3 flats to my client. So there is some problem. He has not given the flat and he has constructed all other flat except the owner's flat. So we filed a suit. In the suit, there is an interim order. And as per the interim order, the court said, don't do this, do that. And there is a status quo order. After that, the defendant, they have chosen not to file any objection to that application. Till date, till today, there is no objection left. What happened, Lordship? In the meantime, some of the parties come before this court, filed a writ petition, saying what? That give us the electricity connection. All right, the court has not given the order that give the electricity connection. Court has given the fact in the order and then said the epidicial dependency of the writ petition will not be a bar for the epidicial to consider their case if there is no other order from any other authority. Immediately, Lordship, we filed an application before in the writ petition for impleading us and giving the whole detail. On that day, Lordship, before we came to the court, on the 10:30 itself, they have withdrawn the writ petition. They have withdrawn the writ petition, Lordship. It was before Honorable Justice Manish Chaudhary. So when the matter called, my matter was not called for. I said, what happened? I filed an application. The Manish said, no, they have withdrawn the writ petition without any liberty. No liberty was taken. The stay order is vacated specifically. Justice Manish Chaudhary said any interim order passed is vacated. And my application is also disposed of accordingly because the writ petition is not there. And Lordship, I have written a letter to the epidicial, and epidicial tell me that there is a High Court order, so we have given. I said now the writ petition is withdrawn. Now epidicial has several letters, Lordship, even in their writ petition, Lordship. I can show you, Lordship, in the writ petition itself, their writ petition, Lordship, there is a document, Lordship. In my document, before I showed my document, Lordship, in their writ petition itself, Lordship, they have annexed a document at page 69. Lordship, that is a dispose of writ petition. Let us see what the epidicial has said. At page 69.
Because even if it's a disputed question of fact with regard to possession, title, everything, under the AERC code, I think there's a provision there where twice the amount of security can be given and they will restore and they will provide electricity connection.
No, that they have not done. That is not done.
Okay.
That is not followed. But the point is, Lordship, the same epidicial, this page 69, Lordship will take note.
Yes.
With reference to the above, the undersigned and inform you the service connection to the flat owners of the building construction by so and so has been processed. Now, at the time of the release of the connection, one person named Anupam De has submitted a petition for not releasing the electricity service in connection to the flat, claiming that the court has passed an order of maintenance status quo on so and so, which has been extended up to so and so. The Honorable Court orders are enclosed herewith for your ready reference. Now the epidicial is not a party in the case so and so. You are requested to take up the matter with the Honorable Court of District and Sessions of Kamrup so that epidicial is nowhere hamper the status quo as ordered by the Honorable Court. This is very correct. It was given. They have not filed any application before the trial court. Then Lordship, page 89. Our writ petition, Lordship. Now after this letter, in our writ petition, Lordship, may please come to page 89. Epidicial, they are very correct, Lordship. I don't know why Lordship approved and reproved. Sometime, Lordship, what happened, I do not know subsequently. Page 89, Annexure 8.
Because I'll tell you why. At one point of time, I am skipping the relevant dates. And at one point of time, before the High Court, they were, I'll forget, it's about 3,000 odd writ petitions pending for electricity connection, disputes of electricity connection. At the same point of time, before the civil court, there was almost more than 1,000 cases where the dispute with regard to electricity was there. And then the electricity board took a decision, at that time AACB as it was, it took a decision that they will not be a party to these litigations and with, because their court provided twice the amount of security and give it. And all these cases were settled so far as the ACB is concerned by giving electricity, and those about within a span of 3 months, about 400 litigations went away.
And that's created the whole havoc in the Guwahati city now. Now we are facing lawsuit because all the hill area lawsuit, they have given the electricity connection. All those are government land. No
Yes.
permission, nothing from
In
the
the
municipality,
AERC
no GMDA
In
permission.
the AERC code is a specific provision for
Yes,
giving electricity connection even in government land.
yes, that is why lawsuit. That's the whole problem lawsuit. Now all the hill area lawsuit, they have given the electricity. And now we are facing the Guwahati people, we are the citizen, we are facing all this problem lawsuit.
No, but nobody has challenged this regulation. Specific
Lordship,
regulation.
please
Where
come to
is
that.
Find out that.
Lordship, there is a that what your lordship is referring to is for the temporary electricity supply.
Yeah.
To issue a temporary electricity supply
No. In a government land.
in a government land as per clause 4.2, if it is government land, an NOC from the government is required.
No, not required. You see that?
As per the latest one.
Okay.
Now they have sent it lawsuit.
Okay.
Now
But
they
your
have
lordship,
sent-
there is a Supreme Court judgment which I'll show you. The position again goes back to what it was, your lordship. So I'll.
Okay.
So lordship, this page 89 first.
Supreme Court, you are referring to AR 17-19-997.
There is a recent one, your lordship, 2022.
Okay. Let's try again. Okay. Yes, Mr. Sharma.
So let's page 89 lordship.
Yes, I am there.
Yeah,
Actually,
annexary.
yes.
With reference to the above enclosed, please find herewith a copy of the letter received from so-and-so of violence of so-and-so in the Honorable High Court order dated 99 against in Mizje case number so-and-so. You are hereby asked to maintain status quo as per the order in case any electrical installation, supply into service in connection, etc. from your side until further order from the court. This is to the manager Ulubari Electricity Subdivision APDCL from the chief executive officer. He has written this letter that don't give because there is an interim order from the court. It is pending. And my lord, that matter is pending till today, and the defendant and the opposite party has not filed their objection till today. No objection till today, my lord. The interim order is continuing till today. Now, lordship, may please come to page 139. Look, I said, lordship, if you have decided all this, suddenly why you have changed your mind? Page 139. Now it is from the subdivisional engineer Ulubari Electrical Subdivision APDCL Ulubari. Then the compensation bill amounting to so-and-so of so-and-so. Evidence revealed that you were directly or indirectly involved in the act of malpractice. A statement showing an involvement along with the assessment bill are enclosed therewith. You are requested to pay the assessment bill within 7 days from the date of presentation of this bill. Failing which an amount in the assessment bill shall be treated as arrear dues against you, and your service connection may be disconnected as per 126 of the all these notifications are there because only a service connection was given. But private personal connection was not given to all this person. Because it is the completion certificate is not there, my lord. Because GMDA and GMC, they said if you complete the building, if you come, then you have to take the completion certificate. With the completion certificate, you will get the electricity connection. That till today it is not there also. It is not completed even. Now please come to page 129.
Yes.
Because they have sent a legal notice to the APDCL. And this is the reply of the APDCL to the legal notice. With reference to the above subject, undersigned here honor to inform you that one person named Onupam De has filed a case number so-and-so in the Court of Civil Judge number 2, Kamrup so-and-so against Rupam Chatterjee. So-and-so, all these names are there. And then in that case, the Court of Civil Justice passed the order of maintenance status quo in respect of the subject matter, and the copy was furnished by Anupam De to this office. Accordingly, the order has been extended from time to time by the court. The matter was referred to the higher authorities as per their suggestion. It is to be informed that until the status quo is vacated, the service connection may not be released. This is the decision of the ACB, APDCL lawsuit.
Where is the order of the court? Trial
Lordship.
court? Where is the order of the trial court?
Trial court lawsuit.
That in the status quo?
Lordship.
Where is that?
Lordship. Page 83, Lordship.
83.
Yes. That lawsuit I'm reading in the middle. That the suit is
Just a
filed.
moment, just a moment. So
Lordship.
where is a copy of this petition? Miss case 7, what you call? Either title suit or miss case, where is the copy?
Page 67, lawsuit miss case.
67.
Page 67, miss case, plaint is there, is started that lawsuit.
No, okay, it's okay. I've seen that.
44 is the plaint, 67 is the miss case.
I've seen that. Yes.
Now lawsuit that the suit was filed and that there is a miss case and that there is an agreement between the so and so between the developer and for there is a prayer for restraining the opposite party number 1, his man, agent, etc. from handing over, transferring any portion of the schedule C and D flat. Lawsuit get it.
You're reading where?
Lawsuit I'm reading in the middle of the page 83.
83. Okay. Yes.
Till the completion of the building to be constructed in the opposite as per the agreement of development land, restraining the opposite party number 1, his man, agent, etc. from handling and transferring the schedule C and D other than the petitioner for mandatory injunction directing the so-and-so heard so-and-so. However, in view of the material on record, the opposite parties are directed to maintain status quo over the suit land till the next date fixed by the so-and-so. Then, no affidavit, nothing, lawsuit, no objection. So the page 84. Page 84. It is after 2 years lawsuit. The original order of 19/9/2019. Now this is 24 to 2021.
Yes.
Now here again say, both the parties have seen the petition number so-and-so file on behalf of the petitioner for extension of the status quo order passed in this so-and-so. In view of the urgency of the matter, prayer for extension of the status quo order is allowed. According to the order, the so-and-so shall continue until the further order in this regard. The opposite party is silent regarding the filing of the eviction law. And till today, no objection is filed. Though they appeared, no objection till today lawsuit. And during the pendency, this writ petition and all this, then withdrawn. That is why lawsuit, what I am on lawsuit, I am not against the APDCL. APDCL earn money. My point is lawsuit, the people who lost the lawsuit on the court lawsuit, because when there is a court order, the people think that no one will interfere in the lawsuit. Lawsuit, please come to 96(4) SCC 62. I am directly on that lawsuit. I am not against the APDCL law. The APDCL will give connection, APDCL will earn money. This is their question of revenue. They will give the salary to their employees lawsuit. I am not on that lawsuit. I am on lawsuit that when there is a court order, why someone will violate that lawsuit? And doing all these hanky-panky lawsuit. Sometimes you file a writ petition. We are filing an application for interviewing the writ petition. You withdraw the writ petition without taking liberty. And then you will continue with the electricity.
Which paragraph here?
Lordship, it is the paragraph 17, 19, and 21. It is head note is there in page 625, Lordship, in a nutshell, Lordship. But I will read the para 17, 19, and 21. Head note is page 625, Lordship. Where an act is done in violation of the order of stay or injunction, It is the duty of the court as a policy to state the wrong and right and not allow the perpetuation of any wrongdoing. The principle that the contemner ought not to be permitted to enjoy and or to keep the fruit of his contempt is well settled. Undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate direction for remedying and rectifying the thing done in violation of the order. The inherent power of the court is not only available in such a case, but it is bound to exercise it to give an effect to the Supreme Court, if necessary, by overruling any procedural or other technical objection. The Article 129 is a constitutional power, and when exercised in Tenet 142, all such objects should be given way. The court must ensure full justice between the parties before it. The corporate failed to be here, Lordship, then that paragraph is there in para 28. I will read para 17, 19, and 21, Lordship. I am on that, Lordship. If the court order is there, you cannot do all this hanky-panky, Lordship. That too, when you decided not to file the objection in the suit, your party, notice served, you have appeared. And builder is a caveator in the suit, Lordship. He is a caveator, Lordship. By filing caveat in the first day itself, he was heard while the order was passed. Page 635, Lordship, para 17.
Yes, I've seen that.
Yes, Lordship, get it. The principle that the contemner ought not to be permitted to enjoy and to keep the fruit of the contempt, as well as in Mohammed versus so-and-so, the court held clearly that undergoing the punishment for contempt does not mean that the court is not entitled to give the appropriate direction for remedying and rectifying the things done in the violation of the order. The petitioners there in giving an undertaking to the Bombay High Court. It is acted the breach of the learned single judge held them guilty of contempt and imposed a sentence of 1 month imprisonment. In addition thereto, the learned single judge made an appropriate direction to remedy the breach of undertaking. It was contended before the court that the learned single judge was not justified in giving the aforesaid direction in addition to punishment. The petition upon contempt of the court. The argument was rejected, holding that the single judge was unique quite right of giving appropriate direction to close the breach of undertaking. Then 19, Lordship. To the same effect are the decisions of Madras and the Calcutta High Court in so-and-so versus so-and-so. It was held by the full bench of the Madras High Court that where an act is done in violation of the order of stay or injunction, it is the duty of the court as a policy to set the wrong right and not allow the perpetuation of the wrongdoing. The inherent power of the court, it was held, is not only available in such cases, but it is bound to exercise it to undo the wrong in the interest of justice. That was a case where a meeting was held in a century in order to an order of injunction. The court refused to recognize this holding of the meeting.
Just wait.
Lost. Prime on, my lord, in the paragraph 19, last line. The court refused to recognize the holding of the meeting in a legal one. It put back the parties to the same position as they stood immediately prior to the service of the interim order. I am there on, my lord. What I am on, Lordship, if the order is passed, order is there, you appeared, you know about the order, Now doing all this. Lots.
You can hear me?
Yes.
You can hear me?
Yes.
Yes.
Yes. So what I'm on, my lord, I'm in the last line of the paragraph 19 lawsuit. That would put back the parties to the same position as they stood immediately prior to the service of the interim order. Now, my lord said that now the Supreme Court judgment is there, all this their orders, APDCL order is there. I know, my lord, but doing all this hanky-panky lordship, sometimes you file a writ petition, take an order, going to the APDCL, that you give the APDCL order, take a connection, and then in the next day you withdraw the writ petition.
No, Mr. Sharma, you see, still we are in a difficult position. Number one, insofar as the suit is concerned, I've seen that page 67, the injunction application, APDCL is not a party there, number one.
Yes.
Number two, the status quo order would not be applicable on a non-party in a suit.
Yes.
Third thing is that in this skipper case, what had happened was that the DDA auctioned up a piece of land,
Lord.
which the skipper construction purchased. It did not make payment to the DDA. But in the meantime, they collected huge amount of money. And therefore, Supreme Court in SLP gave a direction to maintain that not to create third-party income rents.
That is.
And they agreed, they gave an undertaking without disclosing that prior to that, they have already taken few crore rupees from the parties. This was never disclosed.
That is my.
So in that, it is in that context that the court is Supreme Court is now enforcing its orders.
That is my case, lordship, that leave the corporate bail. Here in this case, what happened, lordship? This developer, he is selling all this property, doing all this suit. He has not taken anything. He has not filed his objection, nothing, and getting everything, lordship, violating the court's order. He is earning money. He is a party. He is a caveator. He is doing all this. That my point is, lordship, my point is that against that caveator, lordship, against the developer, lordship, who is doing? These parties are this APDCL. Why I'll make APDCL a party? APDCL has rightly said, you go and take the order from the court. The APDCL has given 6-7 letters, not one, lordship. Now, after the writ petition order, lordship, now they have sensed their view. Earlier, they have written 6-7. So, lordship, issue notice. I'll satisfy. Let them appear, lordship. Let them appear, lordship. Because he is there from the day one. The developer is there from the day one. My case is against the developer.
Okay. Shall I issue a notice on the prayer for interim relief then?
Yes, Lord. Now, lordship, cannot, lordship.
Two issues, your lordship, I'd like to clarify. Firstly, the
Sorry.
On one, I think.
Yes.
Baba on one, I think.
No, I'm getting your voice, but it's very low. Just speak.
two issues which I'd like to clarify, your lordship. Firstly, your lordship, the parties were filed the earlier writ petition, when they were not before the learned court below. So that was one of the grounds taken in the writ petition, that even though we are not parties before the civil court, the status quo order, your lordship, will not apply to us. And secondly, your lordship, After that, in May of 2020, the Supreme Court order came, which says that it is not the business of the distribution company to meddle in the dispute between the owner and the occupier of the land. All we have to determine is to check who is in actual occupation of the land and give the connection, because electricity is a fundamental right.
Which is that?
And second year of the status quo order, perhaps it was, if I may quickly take your lordship to the orders in the application under order 39, the prayers in the application under order 39, which is at page number 78, your lordship.
No, with the prayer which is being made by Mr. Sharma,
Your lordship.
on the issuance of notice, I think
I have
we
noted
won't go into the merit
I
now.
have noted.
There's just, since I
Paragraph
don't,
number 7. This
since I
otherwise,
don't know of this judgment, I'm just noting it down.
lordship.
See, I can read this judgment if my learned. I am not against epidicial, my lord, and what my learned friend, he has been briefed like that. So the parties in the writ petition, this wife has come before this court and all the husbands are the party before the trial court. That's the whole problem. My lord. So sometimes lordship there is a court order, so I know how to just hear the court order, lordship, I know.
Wife standing in front of the husband is a well-known phenomenon. We can't blame anyone.
And at least lordship, trial court lordship, I know how to play lordship. This page 116 of my petition, lordship, consider. It is already there, lordship. This petition is pending, and lordship, the developer has not given it till today after the court order, lordship. They are also they violated. Page 116, lordship, can see for a moment. Now they said who is the party, who is not there. Lordship, can see page 116. There is a provision in the CPC, and under the provision of an application under Order 11, Rule 15 and 16, reduced section 151, I filed this application that to give a direction to the developer that who are the party. And then the page 121, the court given an order, then given a notice, page 121, lordship, can see. I am not that here, lordship, trial court, I am there, lordship, so I know how to bring the parties in the whole, lordship.
Mr. Sharma, and senior counsel, assisted by Mr. T.K. Bhunyal and counsel for the petitioners, and Mr. K.P. Patak and standing counsel for APDCL.
Respond numbers 1 to 7.
Number 1 to 3.
1 to 7.
1 to 7. GMC and GMDA. You'll be there. Mr. P. Nayak, standing counsel for GMC and GMDA. Representing respondent numbers.
A small prayer, lordship. If the GMD and GMC can take the instruction whether that
8 and 9.
certificate of completion certificate is given. Only that much, lordship, nothing.
Okay, 8 and 9. Issue notice of motion, including notice on the prayer for interim relief, returnable on so and so. Requisite extra copies of the writ petition be served on the net state and departmental council appearing for respondent numbers 1 to 9. Next, the petitioners shall take steps for service of notice on the private respondent numbers
10 to 15 minutes.
10 to 15 by registered post with AD. Liberty is granted to the learned counsel for the petitioner to collect postal receipt number and submit postal track report prior to the next date of listing. Next paragraph. The learned standing counsel for GMCA shall inform the court on the next date as to whether completion certificate has been issued in respect of the. Where is the description of building?
No,
Where is the description of building?
5, I think, lordship.
Oh, I don't know.
64, lordship.
64.
Apartment, my lord.
Page 64, lord.
No, they'll not be able to locate like that. Either GMC permission or something like that. They'll have specific, otherwise they'll not be able to track out.
But if, my senior friend can place the NOC laws issued by the GMC or GMD.
Lordship, there is a notice given.
Mr. Sharma, he is right. Some NOC for construction or something.
Yes,
Without that, they will not be able to track.
I'll give it to him. Lordship. It is there.
Acha.
In the
If,
trial court record, it is there, I'll give it to him.
if appropriate particulars are furnished by the learned counsel for the petitioner. List on, give a date.
1970.
I'll take a break and come back. This copy of petition I'm returning.
Yes, Lord. More RTA pending as well, GMD, an idea.
For award of LPG distributorship, my lord. My lord, the pursuant to advertisement dated, my lord, 12/6/2018, the petitioner submitted her application. My lord, will find the application at page 32. Page 32 is my application, my lord. My lord, kindly see the serial number D, my lord. Type of distributorship, DKB, Durgam Kshetriya Bitrap Scheme Distributor, my lord. Category
Yes.
open, women. Name of the location, my lord. Serial number F, Vidyapur. So I have applied for that, my lord. And subsequently, I was selected, my lord. Annexa B, page 35. Subject,
Yes.
my lord.
Yes.
Application for award of LPG distributorship of IOC at Vidyapur district, Golaghat, under open W category, advertised dated so and so, type of distributorship, DKV, my lord. So I was asked to deposit certain amount, my lord. I have deposited it. And my lord, I have submitted all the documents. Annexa C, page 38. This is a submission of security deposit and documents details, my lord. Subsequently, my lord, my land was verified by the IOCL authority, my lord. And they have sought for clarification from the circle officer, page 42.
It's a forest land.
Yes, my lord.
If it's a forest land, we can't permit the ICL to
Well, in fact, there is a provision, my lord, for conversion for non-forest.
forest land
Yes, my lord.
after TN Godavarman.
In fact, they have the Department of Forest, they have processed my application also, my lord.
No, that is okay. But
In fact, my lord, I have made a categorical statement, my lord, in that area, my lord. In that area, there are houses, there are schools, there are offices, which
no,
are not.
that can be there. That can be there till they are not evicted. But the problem is that by virtue of an order of the court, can we permit that, because after that there are a series of judgments after Godavarman, there is this particular green tribunal set up. The conversion will now be as per the scheme which is various orders of the green tribunal.
In fact, I
It is because of that green tribunal that the state government had to amend several laws. This 2008, what you call that, Assam wetland.
Yes, my
All these things have come up after that.
lord, I have gone through some recent order of conversion also, my lord, for non-forest use.
So,
Right now, I don't have, my lord. That's why I have checked with my brief, my lord. Right now, I don't have, my lord, but I have gone through it. I can produce it, my lord. In fact, there are instances, my lord, on Hindustan Petroleum, they have allotted agency in a forest land, my lord, after conversion. That order is also with me. Right now, I don't have, my lord, but I can produce it, my lord.
No, if it is a forest land,
Yes, my lord.
then it can't be a private patta land.
Oh, no, my lord, it's, yes.
So you see, it's a matter of chance whether you get your land converted.
Yes,
Until then, they can't wait.
because, my lord, The entire location they have offered, my lord, it's a Gulgam Statue Bitrok scheme, my lord. And that location, its entire location is under forest area, my lord. The Biddapur area, I can show from the document, the Biddapur area is a forest area, my lord, under the Uriamghat forest range. So there is no patta land there, over there, my lord.
If it is not there, then it can't be helped. But we can't, by order of the court, we can't permit.
See, my lord, they have already
gross
processed it, my lord,
illegality.
for
I can
conversion.
only issue a notice at this stage, no interim order.
In fact, I'm praying for a notice, my lord.
But that's still okay.
My lord, petitioner's case is that, my lord, he has an encroached plot of forest land. That is being offered now, and we have rejected it. And my lord,
Can issue a notice and because he's not insisting on an interim order. Because I follow the principle also that dag achhe hain. Litigations at times is welcome to the lawyers also.
Right.
Will not discourage that. And in the meanwhile, congratulations.
Hello, thank you. I'm grateful.
Mr. N.J. Khatuniar, just wait. Mr. N.J. Khatuniar, learned counsel for the petitioner, as well as Mr. M.K. Chaudhary, learned senior counsel.
If you for restaurant number 1, 2, and 3.
Assisted by Mr. P. Bharadwaj, learned counsel for respondent numbers 1, 2, and 3. For forest, we will be appearing. Okay, Mr. K.V. Pathak, learned study counsel for the forest department, appearing for respondent number 9. And rest of them are you?
Yes. 4, 5, 6, 7.
And Mr. S. Barwar, and government advocate, appearing for respondent numbers 4 to
4, 5, 6, 7.
8, 4 to 8. Why is this border magistrate required?
Because my lord, this area is a disputed area built, my lord. That is why their permission is required. Page 58, my lord. Page 53.
Oh, it's okay. I'm just asking you.
In fact,
they are a necessary party.
yes, my lord.
Okay.
They have given permission, my lord.
Okay. Issue notice of motion returnable. Issue notice of motion, including notice of the prayer for interim relief returnable on in 4 weeks. Requisite extra copies of the writ petition be served on the state and department council in course of the day. List from so and so.
Yes, obliged. Obliged.
22.
Wait, please, your lordship.
And I have 22 Nazim Belak 24 22. At 22, no?
20.
No, this representation won't help you. You'll have to file a application for remission.
Yes, my lord, that is under Rule 49, the Assam Financial Rules. A remission of the Kisht money.
But this is Mr. Hawk. You'll have to dismiss your petition. This representation is nothing.
My lord, in fact, my lord, the settlement was suspended by the government of
It is okay. You may have a good ground.
My lord.
You claim that you have run the operated for 1.5 months only.
My lord.
Correct. But that would.
But my lord, they have subsequently initiated Bakijai case.
No, but having instituted Bakijai case, the court can't do anything. Against a Bakijay proceeding, I can't entertain a writ petition.
Despite of the facts that the defendants will about the situation under.
No, once a case is, you see,
My lord.
you forget this Bakijay.
Right.
Correct.
Right.
Somebody files a complaint case, NI case. Can you rush to the High Court? If somebody files a civil suit, can you rush to the High Court that no case is made out, false case? A Bakijay proceeding is a judicial proceeding.
Right.
Under the BDPR Act. Unless you file an application under section 9, after limitation is crossed, you can't even file that.
My lord, the executive, chief executive officer of the Zilla Parishad, my lord himself know that the Parkhat was not operating, my lord. Instead of that, despite of the fact that, my lord, he was insisting of, my lord, claiming the remaining amount, my lord.
Fact, my lord,
No, it is okay. You see, we can't have answers for everything.
Right.
Say, supposing I have taken a house on rent. Correct.
My lord.
But I had a business which is closed because of that COVID. 1 year I did not operate my business. Will the landlord not ask for rent? And if the landlord asks for rent, I'll have to request him for a remission or adjustment, something like that. If you have not operated for whatever reason, but all you can do is ask for remission. Writ petition will, we can't entertain against a Bakijay proceeding.
Then, my lord,
What is the provision? Section 9, BDPR Act. Bengal Public Demand Recovery Act. Note for the BDPR Act. It will have forest laws. Forest laws. Which you're using, right, is 30 days. When did you receive that notice? Bakijay notice?
Page 34, my lord.
Page 34.
Second paragraph, we had apprised him of his legal right to file a petition denying his liability.
34.
34, my lord.
So, Mr. Hawk, you'll be losing a valuable right. We close it with liberty to you to approach both remedies, either under BDPR Act
my lord.
or to file a prayer for remission. Remission is under 49, you say?
49 of the Assam Panchayat Financial Rules.
Okay. But Mr. S. Hawk, learned counsel for the petitioner. And Mr.
P. Handick, my lord.
P. Handick,
On
learned
behalf of K. Kumar.
learned counsel appearing on behalf of Mr.
K. Kumar, my lord.
K. Court,
Senior Standing Counsel, P.
learned senior standing counsel for Panchayat,
Panchayat, my lord.
representing respondent numbers
4, 5, and 6.
4, 5, and 6. And Mr. K. Gogoi and government advocate appearing for respondent number
7 and 8.
No, and who will be appearing for this 1, 2? Inland water is Mrs. M.D. Bora. Transport? Ms. M.D. Bora, the standing counsel for respondent number 1, 2, 3. And Mr. K. Gogoi, government advocate appearing for respondent number 7, 8, and 7 and 8. Next, Bora. The learned counsel for the petitioner has submitted that the petitioner was settled with Duba Churi, Dandipara. Spelling you'll find, I'll flag it, huh? Parghat for the year 2018-19. However, by an order dated 7/9/2018, the authorities of inland water transport had suspended the plying of all mechanized boats in all ferry services within the state of Assam. Accordingly, the petitioner claims that he was able to operate the Parghat only for about 1.5 months. It is submitted that although the respondent authorities in the Panchayat department were aware that the petitioner could not operate the Parghat for the entire tenure, they had initiated a certificate proceedings within bracket Bakijai proceedings before the court of certificate officer additional deputy commissioner Bongaigaon, which is registered as Bakijai case number Bonga BONGA /LBD /5/2022 dated soon to the petitioner is in receipt of notice dated 8/4/2022 in Form 3 of the BDPR Act, Bengal Public Demand Recovery Act, 1913, within bracket BDPR Act for short, requiring deposit of rupees 1,05,000 on account of demand with interest at the rate of 6.25% per annum and cost of realization. So in this regard, the petitioner has submitted that the Bakijai proceedings was not sustainable. Next paragraph. Having heard the learned standing counsel for the Panchayat department, the court is of the considered opinion that in respect of claim made by the Zilla Parishad for recovery of case money, the petitioner would prima facie be entitled to two remedies. Firstly, by approaching the competent authorities under section 49 of the Panchayat.
Assam Panchayat Financial Rules 2002.
2002. And alternatively by filing an appropriate application in the proceedings of the Bakijai, in the Bakijai proceedings, Bakijai certificate proceedings under section 9 thereof by denying liability. Full stop. There is no material on record to show that because of the reasons assigned by the petitioner, the court can prima facie held that the claim for this money is illegal. Full stop. Hence, it would be appropriate to relegate the petitioner to approach either of the remedies, to avail either of the remedies available to him as indicated above. Accordingly, this petition stands closed. With observations as indicated herein before. Next paragraph. For the purposes of contesting the matter before the certificate officer, the court is inclined to observe that this writ petition was instituted on, was filed on 25/5/2023. And therefore, from the date of filing till the order passed today, the petitioner would be entitled to claim extension of period of limitation. Full stop. With the aforesaid observations, this matter stands closed.
23.
Very clear, the lordship. Lord, one school is before your lordship. Lord, they have allotted 5 bighas of land by the government, my lord. But thereafter, my lord, some encroachment is there, my lord. Therefore, page 15, my lord. An application was filed before the my lord, local MLA to take necessary action against the encroachers, my lord. Thereafter, my lord, circle
If it's an
officer.
encroachment, you'll have to file a suit or you'll have to draw up a proceeding. How can
My lord, I have
interfere?
filed an application before the deputy commissioner, my lord.
Oh, the deputy commissioner, their hands are tight. When there are civil courts, what you call,
One
there,
school, my
deputy
lord.
commissioner can't do anything.
My lord. This page 22, my lord. There's simple prayer before your lord.
Page 22.
Page 22, my lord. This is the Bhanegula, my lord.
Yes,
May I read, my lord?
yes.
এটা নিবেদনে যে ইমান নম্বৰ বিধানসভা সমষ্টি দলগাঁও বিধানসভা শিক্ষাখণ্ডৰ অন্তৰ্গত 2 নং মোল্লাপুৰা প্ৰাথমিক বিদ্যালয়ৰ 5 বিঘা মাটিত ৰাইজে আজি প্ৰায় 15-16 বছৰ ধৰি অবৈধভাৱে বেদখল কৰি ঘৰ-বাৰী বনাই আছে।
No, just tell me, Mr. Bhuya,
My lord.
this is a letter by the headmaster of a school, right?
My lord.
No, if this can be entertained, why not your petition to the deputy commissioner that there is an encroacher on my land, please evict him. Everybody will start approaching the deputy commissioner. Why we need a civil court?
Because, my lord, for eviction of the, my lord, this land must settle land, my lord. The deputy commissioner may, my lord, 18 to, my lord, he can initiate.
Where is the power to the deputy commissioner? Show me that. If the land has been grabbed, we have a land grabbing act.
Land grabbing as is there, act is there, my lord.
Then you
my lord,
don't approach that.
18 to, my lord, 18 to, my lord.
Don't approach that. This will be a misconceived writ petition.
My lord, that is true, my lord. But my lord, school, my lord.
No, we'll not understand that.
My lord.
We'll not entertain that. School is the highest litigating party in
My
this,
lord,
what you call teachers and school, highest litigation in this court.
My lord.
And not everybody is right.
My lord, although, my lord, this is premature, my lord, litigation, but that, my lord,
No, you close it.
deputy commissioner
You
may, my lord, consider my representation only, but that must, my lord.
will not, will prohibit him from considering it. He can't do that exercise. You show me the law that any citizen approaching him will start eviction process.
But earlier they had interfered into the matter, my lord. Some parts were removed, my lord. Some
You
person will
give us
report.
the name and particulars, we'll give strictures against them.
My lord, in paragraph, my lord, read petition, I have stated, my lord, there are some people are, my lord, enclosures were removed. Some are there, my lord, presently, my lord. 2 or 3
No, no, you
houses.
see, eviction process by the government can be done, but not by a private person. That can't be entertained.
This is, my lord, on school.
It's a misconceived
educational
petition.
institution,
I'll
my
be
lord.
dismissing it. But Mr. T.K. Bhuyan and the counsel for the petitioners.
My lord, dismissing, my lord.
Yes.
Dismissing. Then, my lord, withdraw, I will withdraw, my lord.
Okay. Mr. T.K. Bhuyan and counsel for the petitioners. Ms. G. Hazarika and government advocate appearing for responding numbers.
Appealing for respondent number 1, Lordship.
Number 1.
SC agreement.
This is, my lord, liberty to appropriate remedy, my lord.
And for 2, 3.
And Mr. K. Gogol and government advocate appearing for respondent number 2, 3, and 4. Next one. After some deliberations, the land council for the petitioner seeks to withdraw this writ petition and approach the appropriate forum. Please allow the matter since dismissed on withdrawal.
Liberty candidate.
Liberty content.
All right.
I said prayer is allowed.
24,
My lord, I apologize to interrupt, my lord. In item number 23, Miss MD Bora was the transport department was the party, my lord. Miss, but we have not been served the copy and the name has not been reflected. My lord, the name may be reflected in the cause list.
Restriction reflect the name of SC
Transport. My lord.
transport by listing the matter next.
Okay, sir.
You contact the lawyer, his phone number may be there in the file. Take the file and call him.
Okay.
Yes, Mrs. Devi.
My lord, regarding acquisition of my lord, Terracotta land having dwelling houses by the respondent authority, my lord. On 4th of May, my lord, the staff of respondent, they entered into the
You will
premises of
not
the. but they
take
did not
position,
and
Mrs.
fixes
Bora.
4 pillars on the 4
You
corners
will
of the
not
house
take position without due process of law.
without any
Yeah,
formal
Lordship,
procedure, my lord. prescribed
whether
by law.
it's true or not, let me take instruction, because without acquiring the land by the competent authority, they cannot, actually National Highway Authority cannot enter the land, whether it is true or false. Some procedure are there, Lordship, under the National Highways Act. They have to
By Friday next.
Next Friday, yes.
This Friday is 2nd June. You can get instructions by then.
Yes, Lordship.
My lord, I may kindly be protected, my lord.
But she says that she will not take.
But because they will never enter in such a
My
land,
peaceful
which is
persons
not
and
acquired.
will be disturbed, my lord, as because my
They will not
husband
do
is
it.
bedridden.
Once Mrs. Bora says I have faith on her.
My lord, it is evident annexure from annexure 1, my lord.
No, they have only fixed a pillar,
Yes, my lord.
but they will not take it over. We are
Let me
taking it on
take
Friday.
instruction. Yes.
We are not giving a long adjournment.
Friday next,
22nd of June,
22nd of June.
2nd, 2. All sides are duly represented. So, in view of the grievance, the nature of grievance of the petitioner, Mrs. R. Bora Leonard, standing counsel for the NHAI,
1 and 3, Lordship.
respondent was 1 and 3. Raised for some time to obtain instructions as to whether the land of the petitioner is earmarked for highway project. List in the motion column on 2/6/2023. I said all sides are represented.
I'm appearing for respondent 2, my lord. Standing counsel NSIDC.
Okay, Mrs. Singh, first name I forgot. P. Singh, standing counsel for respondent number
2, lordship.
2.
Respondent number? National Highway and Infrastructure Development Corporation.
Okay, respondent number 2.
Also, Lordship, the respondent number 4 has to take instruction whether the land was acquired or not.
NCLs who will be there? You will be there. Miss
Revenue officer.
J. Gogoi, study counsel for NCL's Autonomous Council. Asha, respond number 4 also. You also get information. Correct. Come here. I can't hear you. Come here. Yes,
It's only verbal instruction, Lordship, that we have served notice to the Gambra of Haramjao Mojadhara. Actually,
you serve notice to Gambura and take her land.
on some previous case also, there are
Oh, then we'll have to
Says
give a restrainment order. You can't do that. No, that can't be done. Then
Proper
you,
not-
then you are inviting an, yeah, no, then we'll issue a notice and state.
this is only verbal instruction. Lordship.
No, but still that can't be done. If you
I
do
should
it,
be
do it in
protected, my
Gambura,
lord.
take Gambura's land. But serving notice on Gambura and taking her
I am
land
giving proper
is
instruction.
improper. No, we'll state then. Then we can't have faith on the autonomous council. अच्छा सबका चलेगा the by filing this requisition under Article 226 of the Constitution of India, the grievance of the petitioner is that without serving any notice of initiation of land acquisition proceeding, the authorities of North Kachar Hills Autonomous Council have reportedly earmarked the land of the petitioner for extension of the national highway. Issue notice of motion returnable in 3 weeks. Requisite extra copies of the petition be served on the internet. CGC and Departmental Council in course of the day. If CGC will be appearing,
I'm waiting for, we are instructed to appear the more,
for one also.
one also.
Acha, inside Harbor for one also. Next para. The having regard to the projection made by the petitioner that no notice of acquisition was served on the petitioner, the North Kachar Hills Autonomous Council, including its revenue officer, are restrained from taking over possession of the land of the petitioner without following due process of law. Next, the petitioner shall produce a certified copy of the order before the respondent brings the order to the notice of the said authority.
$25.
Maybe, Lord. In this case, my lord, this petition is directed against the notice, my lord, dated 4/3 to the 23 annexer, my lord.
But Mr. Das, I did not find any statement here
My lord,
that after your lease period was over,
my lord.
you handed over physical possession of the fishery to the authorities.
Yeah, that is my lord. Yeah, they are probably actually on our request, my lord. We have already approached the government, government.
No, extension is okay.
For extending the period of settlement, at least for a period of 3 years, my lord. Against which, my lord, only 1 year was granted, my lord. So to which we have refused to accept that this order of extension, my lord. And for that extension period, my lord, now by the input notice, my lord, that a 4/3 to the petitioner society has been directed for making deposit of rupees 86,500 rupees, my lord.
Yes.
That is actually my decision. It was without any authority of law, because actually, for physically person to the extension of the physical person was not handed over to us, my lord. Not,
That's why my question is
my lord.
that Did you hand over position? That is, I have got no statement
Yeah,
here.
but as soon as my period of settlement is expired, my lord, we are not allowed to enter into that fishery, my lord.
Where is that statement?
So that actually, we have said by we are not in position, my lord, that you have said, my lord.
Where is that? I did not find it.
So they actually,
Before 24/6/2022 that you are in position.
my lord, till the expiry of this original period of settlement, my lord. Period of settlement was that is.
Because in none of the fishery cases I find
My lord.
that the government takes over position, what you call, of the fishery.
No, as soon as this the period is expired, my lord, that no, nobody is allowed to enter into the fishery, my lord. That is the position, my lord.
Yes. Who's you?
Otherwise, they
You are
will
paying for
continue
fishery?
without making any payment, revenue, my lord. Fairness can go in the deep fishery has refused to accept the order of extension, my lord. Which is a question of making the payment of the revenue for that period, extended period, my lord.
No, correct.
Over and above, my lord, the fishery society also subsequently subjected an application before the government of South for extending the period of settlement for a period of 3 years, my lord. In pursuit of which, and the several letter was issued to the deputy commissioner, my lord, for submitting a report, my lord. But until then, that report has never reached the government of Assam, my lord, in the fishery department.
Yes, Mr. Barwan.
In fact, here the petitioner has impugned the order, the official communication between the deputy commissioner and the joint secretary. That I don't know how he has obtained a copy of it, but this
It's
is not
always available.
This is this.
It's a free world. It is available.
Page 24. Page 24.
You must know the right person to give you that.
So that is his impugned order. In fact, as regard this,
Because you see, if the
decision-
government was so very sanguine about these things, they would have investigated the matter and had that person arrested.
Well,
You know, in the army,
yes,
they don't permit you to have your personal mobiles into the field area.
yes.
They don't, if very sensitive documents are being handled, you're not permitted mobiles inside. They give a departmental mobile. But personal mobiles are not allowed.
Yes, within that periphery, yes. Area of operation.
And once found, they will be suspended, there will be a court martial.
In fact, in this respect,
If you can introduce that in the government departments, it will be very good. No document will be out. All secrets will be maintained.
It is a received copy. I don't know what received copy. This is a received copy of the deputy commissioner's office, which has received.
No,
So
but
he-
I just wanted, I'm interested in knowing
Yes.
that if you are not given him the position,
Position.
probably at page 23, my lord. The order of extension, my lord, it was specifically mentioned, my lord, if I did, position of the fishery is to be handed over to the petitioner society, pursuant to the order of extension, my lord. That was not complied with, my lord. It's page 23, my lord. The deputy commissioner will take necessary action
23.
accordingly for handing over position of the fishery after completion of all required formalities as per provisions of some fishery rules, my lord. That means we are not in position, my lord. That is admitted position, my lord.
then you can't do that recovery. Till next date, you don't do that recovery. Heard Mr. Ansidas, London Senior Counsel, assisted by Mr. P. Devan, counsel for the petitioner, and Mr. S. Barwa, Learned Government Advocate appearing for. For all the respondents,
All are state respondents, my lord, no private respondent, my lord.
Yes.
for all the respondents, thanks, Parag. Issue notice of motion return over in 4 weeks. Requisite extra copies of the petition be served on the state and then government advocate in course of the day. Okay. Heard both sides on the prayer for interim relief. So the Learned Senior Counsel for the petitioner. has referred to the order dated 17/12/2021 with the bracket Annex 3 to project that the period of lease of the petitioner for the fishery in question. Just write the name, lease of number 1, Chaukwa, CHAUKKHOWA, river fishery, in favor of the petitioner for 1 year
The river fishery of Borpata district, my lord.
in Bapeta district for a period of 1 year, which contains a direction upon the Deputy Commissioner Bapeta to for handing over token possession of the fishery after completion of all the requisite formalities as per the provisions of Assam Fishery Rules, 1953. It is posited that although the formal handing over of fishery was never done, the respondent authorities are contemplating to take coercive action against the petitioner for recovery of the lease rent for a period of, which period? For 1 year.
For 1 year, my lord.
So
With effect from there is
for the said
36/2022, 29/6/23, my lord. Is that the period is not over, my lord.
for a period from, just give it slowly,
Page 36, my lord. Annexure 8.
for a period from
36/2022 to
36,
29/6 2023, my lord. There is the period for which the 1 year action period of extension was granted, my lord.
only on the projection, to the effect that the fishery was not handed over to the petitioner, comma. Court is inclined to provide that the respondent number P, I, the Deputy Commissioner of Bapeta, shall not take coercive step against the petitioner in terms of his communication bearing number BRF-1/2005 part PART/117 dated 4/2023 within bracket Annexure 8. Till the next date of listing. Next one, the petitioner shall produce a certified copy of the order before the before the respondent 4. Respondent 4 is the additional deputy commissioner, not deputy commissioner. Respondent for additional deputy commissioners. Okay.
Okay, can I pay for a stay of this notice, my lord?
I have said it.
Well.
I have said no coercive measure.
Okay,
Till return.
only
Till
depend, my
return
lord.
date.
And to make sure if my lord, if they are allowed to pay, make the payment, my lord, that's actually on our failure of the default in making payment, then I will not be able to, the pressure of society will not be able to participate in the tender process, my lord. So for that, I am, especially I am praying for stay of this, is not a letter, my lord.
Okay, you will be treated as a defaulter.
I will be treated as a defaulter, my lord, then in that case, I will not be, we will not be able to participate, my lord.
In that,
Just say that no, suspension is again a different proposition. Yes, what do you suggest?
in fact, to be very frank, only now I have unearthed that I am just being supplied with a different writ petition copy because the page were not telling. So finally, I have come to know the same parties before the court with another petition which has been placed before me. So I am totally handicapped at the moment to submit. In fact, so can it be posted?
To you give
the
him a
sort-
copy.
Yes.
Well,
Yes,
Copy was not given to him.
yes.
Yes. That was already it was given, my lord.
No, it was given, maybe the office has misplaced the
Office
file.
maybe right,
The
yeah,
names are same.
Oh,
Which is
okay.
committed mistake, my lord.
Yeah.
Maybe, my lord.
You just
So
give
let
him
it be
copy
at
at 2
2.
o'clock.
Let
Okay.
it be at 2.
Okay, at 2 o'clock.
Publish.
Okay.
26.
Regarding lordship, the particular lands were occupied in the belt and block. Lordship, a similar issue is pending before the division bench, that is PIL 78 of 2012. And the next date is fixed on 23/6/2023.
20,
Next date is fixed on 23/6/2023. And this is
23,
the
6.
order.
I'll issue notice then.
Yes, sir.
I'll only issue a notice in this stage. Heard Mr. R. Dhar and counsel, R. Majumdar, sorry, R. Dhar and counsel for the petitioner. Petitioners. And Mr. S. R. Rao, standing counsel for the BTC, appearing for respondent numbers. Which respondent?
1, 2, 3.
1, 2, and 4.
1, 2, and 4.
I am for three also.
No, you can't do anything. We'll have to adjourn your matter.
Lordship,
We'll have to adjourn your matter. Where is Mr. Rava? Please find him. Please find Mr. Rava in the cause title.
which is number 1 is BTC lordship. Number 2 is secretary. Number 3 is commissioner. Number 4 officer.
Oh, acha.
2 and 4.
Okay, it is at page 13.
Yes,
Oh,
page
okay, okay.
13.
I missed that page. Okay. Okay. Mr. Ravi standing counsel of BTC appearing for respondent numbers 1 and 2.
1, 2, 3, 4.
4 is also you. Acha, 1, 2, and 4. And Mr. K. Gogol and government advocate appearing for respondent number 3. Issue notice of motion returnable in 4 weeks. The petitioner shall take steps for service of provide requisite extra copies of the petition for respondent numbers 1 to 4. So the petitioner shall take steps within 2 days for service of notice on respondent numbers
5 to 57.
5 to 57 by registered post with AD. Next, for a list on so and so. Okay.
My respective prayer is to take the present repetition with PIL 78 of 2012 because the issue is same. Issue here is
Okay.
same.
Any difficulty in approaching court number 1 and making that pair?
Because PIL is
Because-
pending law. This is
Correct. So I will ask the Chief Justice what to do.
no. Lordship, if your lordship transfer this.
Then I'll not pass an order. You move the registry for transfer. Can I transfer matters to the Honorable Chief Justice? Division bench, I'll pass an order to take this matter, take that matter. Very good. You had a wonderful idea. Implement it. File an interlocutory application. Then you will find my order. Correct. Pass an interlocutory order application to issue for me to issue a direction on the Chief Justice what to do. Then you'll find my opinion in the order. Correct. Yes.
27.
Yes, Mr. Saigia,
May I please the lordship?
why we should not be dismissing your repetition?
Against the order dated 4/5/2023 lordship passed by the superintendent of police.
Which 4 by 23, page 22,
Page number
22.
22. Lordship, whoever stated that lordship, police has no right to register the case because the wife of the petitioner has eloped with one Sri Orindam Singh lordship with her own consent as because she is more than 18 years. Lordship, my case, this is not only elope my wife with someone else, lordship. My case is death, lordship, that my child was kidnapped, lordship. Subsequently, lordship, after preliminary.
What is the
inquiry,
age of
lordship, I
the age of the boy, age of your child?
Lordship, 7 years. I have
7 years.
The birth certificate, lordship, annexer E, lordship, page number 29, lordship. Lordship, initially I filed an FIR, lordship, that is, lordship,
Page,
annexer A, lordship, page number 16, lordship.
page number 16.
Yes, lordship. But very unfortunately, lordship, police has not registered my FIR, lordship. As I agreed the same, lordship, again I filed an application, lordship, before the superintendent of police, lordship.
You can always institute the guardianship case and take the child back if your mother, if the mother of the child is taken away.
Whatever may be, lordship,
Can it be a case of kidnapping?
yes, lordship, absolutely right, lordship. The initial stage, lordship, police has not registered my case, lordship, and with a vindictive attitude,
Then
lordship.
you have a right recruit
Excuse
to
me?
you to file a complaint under 156(3).
No,
But
lordship.
that petition will not lie.
No, lordship, as because, lordship, preliminary examination was done, lordship, on basis of my application, which was filed by me, lordship, before the superintendent of police, Kipsagar, lordship. After receiving my letter, lordship, he instructed to do the officer in charge. But officer in charge also recorded my statement. Then thereafter, he intimated to the superintendent of police, lordship. Then thereafter, lordship, superintendent of police itself says that the police has no right. But lordship, as per provision, lordship, 154, lordship, police are bound to register the case, lordship. Can you please, 154(1), lordship? That
If
is
you
the
don't,
information in
if it doesn't
public
under
case.
154, what you call, 54(3), you have a right to approach the CGM.
Concern jurisdictional magistrate under section 156(3), lordship.
156(3), right.
3, lordship. And it was also, lordship, settled by the Honorable Appeals Court in Sakari Basu and as well as lordship Sudhi Bhaskara Tambe's case, lordship.
No, that is absolutely right.
Otherwise also in respect of
Lordship, there is a provision, but my case is different. As because, lordship, the superintendent itself says that the police has no way interfere, lordship. As I agree the same, lordship, I have again.
No, the child is with the
filed an appeal,
mother.
lordship,
If
before
the
that.
child is with the mother, if you want, you will have other avenues also.
In respect of, lordship, page number 22 also, he has the alternative remedy under the provision of CRPC 155(2), lordship. Page number 22 says that it is a, lordship, non-cognizable offense, lordship.
Yes, this is a
Child.
non-cognizable
He is concerned with child, not the wife.
Lordship.
This is a question related to my child, lordship.
Then he has the alternative remedy under 156(3), lordship.
But this is not only the provision of 156(3), lordship, as because
No,
lordship,
this is a mispassive petition.
again
You'll have
file
to-
an appeal before the DIG, lordship, IGP, lordship, Inspector
No, they have
General
no
of Police.
authority over their interference is not warranted in police stations. The
But
law
lordship,
says that
MS code
once you file a
guidelines,
complaint, it goes there.
Another lordship, Lolita Kumari, lordship, is clearly stated that lordship, apex court, lordship.
What does it say? The petition is maintainable.
No, lordship.
Lalita Kumari, show me that passage where it says the police doesn't register, then FIR, then read petition is maintainable.
Lordship, let me, time lordship, next date, lordship, I will.
Oh, we'll get you Lalita Kumari here, don't worry. For that, you don't take an adjournment.
I may be
You-
given lordship.
No.
Metamechanical
Frivolous
adjournment
litigation, you will
for
file and take adjournment.
next date, I will.
No, you
Yes.
should have taken adjournment at the initial stage, not
Already
after
I
spending
will
2 minutes, 5 minutes.
I will place lordship, before your lordship.
If, lordship, I mean, I can read. from-
I'll show it here. Lalita Kumari. At 2 o'clock you come, we'll show you here. We'll just have to get the pen drive.
Then lordship, one thing, lordship.
Lalita Kumari doesn't say writ petition is maintainable.
Yes.
It doesn't take away the power of
Lordship,
156(3).
because lordship, police has initially done verification, lordship. investigation lordship, and
Mr.
they have also.
Mr. Saikia,
collected order,
your
lordship.
petition is a frivolous petition. Why I'll say so? You see, I don't have to even open the file for that. You just look at your complaint. What do you say? That the man with whom your wife has eloped has kidnapped your child. You don't accuse your wife for that. Wife has gone.
Yes, because why I made the party as because lordship the opposite kidnapper itself lordship forgery the birth certificate of my child lordship. Another birth certificate has been found out lordship into their locality lordship. And suppress the original one lordship.
That proves
Where he-
kidnapping.
Where he put
That
his
proves
name.
kidnapping.
Yes, lordship. But lordship, after lordship, I made communication to her lordship, to my wife lordship. But it has came to my knowledge lordship. She also stated, verbally stated that lordship, we find the birth certificate where we put the name of him lordship. Therefore, police bound to register that case lordship. Investigation is required lordship.
We don't know.
Yes, because lordship 156 shouldn't 3 CRPC provision is not only applicable here.
I'm dismissing it.
Lordship has
Lordship, I
We
can
give you,
rely
we
one
give you,
paragraph.
we give you liberty to approach the jurisdictional magistrate.
Lordship.
That is not only one, not only Lalita Kumar, it also this, what you call,
Lordship, in Sakari Basu, and it
Sarkari
was
Basu, huh.
retitled in the Sudhi Bhaskara Tambe Lordship in 2016. Lordship. If Lordship permit, I can read only one paragraph of Sudhi Bhaskara Tambe Lordship.
yes.
Lordship.
With that, we have passed that order in earlier case.
Lordship.
Where is that? You remember the case number?
Lordship.
Sarkari Vasu, SARKARI. Vasu, VASU, na? Spelling is
Lordship, BISU, Lordship.
BASU.
It's in Lordship in 2008 to SCC 409, Lordship.
You'll find that, huh? Yeah, Mr. Gogai's submission is there. At this time, Saikia and counsel for the petitioner.
And Lordship,
Mr.
Sudhi Bhaskara Tambe 2016 6 SCC 277, Lordship.
Which citation?
Sudhir Bhaskara Tambe, Lordship.
Sudhir Bhaskara Kamble.
Tambe, Lordship.
KMB.
Right.
What is the
Lordship,
spelling?
Tambe, TAMBE, Lordship. Tambe.
Kambe, TAMBE.
Citation, Lordship, 2016 6 SCC 277,
277.
Lordship.
At this time, Saikia counsel for the petitioner. And Mr. K. Gogoi and a government advocate appearing for respondent numbers, for respondent numbers 1 to 5. Next para. The case of the petitioner is that his wife has eloped with respondent number 6. And in the process, the 7-year-old child of the petitioner has been kidnapped by the respondent number 6. Full stop. The petitioner had approached the officer in charge of Nazira
Also police.
Adarsh police station, but he refused to register a case. Full stop. Therefore, the petitioner had filed an application before the
Superintendent of police.
Superintendent of Police, Sivsagar, on 3/4/2023 for registration of registration of the FIR. Full stop. However, the Superintendent of Police, Sivsagar, by a letter dated 4/5/2023, had informed the petitioner that the matter was inquired into through the SDPO, Nazira, and it was found that the wife of the petitioner had eloped with her son and married one Shri Parimardan Singh, PARIMARDAN Singh. Spelling is right. If this spelling is right, then who is number 6?
Polymoton.
Who is number 6 then?
ARIMERDAN, Polymoton. Commercial.
Spelling is wrong. You match the spelling of respondent number 6 with that at page 24, doesn't match. Stop. The petitioner was also informed that since the age of his wife was above 18 years and married with the person with her own consent, the police has no right to register a case and bring her back. Stop. Agreed by the said communication dated 4/5/2023, petitioner had submitted a representation dated 12/5/2023 before the Inspector General of Police within bracket administration and the Deputy Inspector General of Police, Eastern Range, Jorhat. Stop. Next, the learned counsel for the petitioner has submitted that he has come to know that in the meantime, his wife and the respondent number 6 have manufactured a birth certificate of the minor son of the petitioner, wherein the father's name is that of respondent number 6, right?
Yes.
Next paragraph. Accordingly, the petitioner has approached this court under Article 226 of the Constitution of India, praying for a direction to set aside and quash the communication dated 4/5/2023 issued by the Superintendent of Police, Sifsagar, and for directing the respondent numbers 4 and 5 to investigate the matter. Next paragraph. The learned government advocate, by referring to the case of at least 2, so and so, I submitted that on non-registration of the FIR, the petitioner has a right to approach the jurisdictional magistrate under section 156 within bracket 3 CRPC. It is submitted that as the investigation carried out through SDPO Nazira, which is reflected in the communication dated 4/5/2023 by the Superintendent of Police, Sifsagar, it is reflected that the wife of the petitioner had eloped along with her son prima facie, the interstate dispute between the parties would have to be resolved in an appropriate court. Next paragraph. The relevant observations made in the case of Sarkari Vasu and so are quoted below. First of all, in view of the well settled proposition regarding the right of the complainant to approach the jurisdictional magistrate in case the FIR was lodged and not investigated. The appropriate remedy would be under section 156(3) of the Criminal Procedural Code. Moreover, the petitioner also has an alternative remedy of approaching the jurisdictional court to take custody of his child in accordance with law. Next, for under such circumstances, the court finds that the writ petition would not be maintainable, as the petitioner has two alternative remedies which have not been exhausted. So accordingly, this writ petition stands closed. Liberty to the petitioner to approach any of to avail any of the remedies available to him in accordance with law. Continue to. We have got your order, counsel, for the income tax matter. We have got the order. We'll take it up at 2 o'clock.
Division bench order was there, my lord. I just, yes, my lord. So for 42 is concerned, my lord, that's a matter where interim order was there. We approached the division bench and it's been directed this matter to Lister 25th.
Yes.
Second thing. Second, my lord, the matter was hard, but could not court due to illness, my lord, could not dispose of the matter. Your lordship may just see, my lord, the order, my lord. First order, my lord. The last portion, my lord.
Okay.
Well, and at the 43 to 45, my lord, your lordship once heard the matter as per the tax division bench. Again, my lord, division bench, my lord, we approached because matter was not disposed of. Again, my lord, some time has been granted. Once 15 days, again, last Friday, 10 days, again, time has been granted. These are the orders are there. So, my lord, I think today it may not be hard. It may, my lord, both sides, 1 hour may be taken, my lord. Both sides may take 1 hour about all the matters. Almost, my lord.
I'll try to take out, I don't know, but I can continue. If it can't be completed today, it can be continued tomorrow. Because of the division bench order, because today I have, in the morning, I have assured few lawyers that I will take up their matters.
Yes.
As their interim orders are, they have a prayer for interim orders. Mr. Goswami, you are also there?
Yes, I'm for the petition. Because there is no tearing hurry to mention this matter like this. I have a grievance, that's why I'm saying. Because I have argued before your lordship, if your lordship recall, I have completed my submissions. Then I have argued before Justice Michael also completed my submissions. So it is wrong to suggest as if for the petitioner, the case is not being heard.
No, I have not submitted.
No, please make it clear.
No, that submission was not made.
Matter heard, you should have got it on a Tuesday. But I have.
No, in fact, Mr. Goswami, in my court,
No,
Mr. Goswami, in my court, Tuesdays and Mondays are same, but Tuesdays I am recording.
Right, but I learned my lesson by giving a consent on the last Friday. And I have learned that on Monday and Friday, I will never give consent. It is for the court to decide if they want to upgrade, I will be ready to argue. But it is not fair to the lawyers who are waiting for their motions to be completed. I felt very bad that day that I gave my consent to the learned Advocate General. It's my fault, but I have learned my lesson. For Monday, Friday, I will never give consent. It is for the court to decide. I will be ready.
We'll try to take up if time permits. You can come late hours.
Day where you can upgrade a matter like this.
I'm not updating. I wanted to
If necessary, it
You
may
can,
reach that
you
time,
can
yes.
we can try at 4 o'clock. If I finish the other matters, I'll take it up.
No,
If not,
no,
then tomorrow.
4 o'clock, what is the 4:30? 4:30, you have it tomorrow, my lord. Why should you have some kind of a pressure for everything?
Tomorrow?
If it is convenient, have it tomorrow. I am ready to argue, but I don't go beyond court times. That's not a good precedent.
You are right, in fact,
Yes, my lord.
because it
I am
ultimately
saying
takes.
Biggest
If you could-
judges of India, Chief Justice Sagla. He appeared before a Supreme Court bench on the last day of his career. He announced that after that he will go to Bombay. He is retiring. So the bench of 3 judges felt that he may need another 5 minutes to complete his reply. So they suggested that Mr. Sagla, we can sit for 5 minutes if you are feeling. No, my lord, it's never done. He looks at the watch, my time is up. It's never done. That's the real spirit of a adherence to the court timings. And he was a Chief Justice when the Chief Justice of US on an official visit landed at Bombay during court hours. He sent his registrar with a note that he is in the midst of hearing matters. He will go immediately after 4 o'clock and meet him. So he never
But-
rose from the court to greet the.
But Mr. Goswami, you know the history
Yes.
of not attending. What happened to the former Chief Justice of Bombay High Court?
No, I know about him because it is mentioned in his autobiography.
No. Acha. Okay.
Sagla's autobiography, Roses in December.
There are other incidents also,
Ah.
which may not be reported, I don't know. But someone suffered for not rising.
I don't know, but I thought that was a precedent worth emulating.
I'll sometime disclose it to you, the names.
Beyond court hours with hearing. It's not done because all of these people are there. They come from a very distance and they will all be in difficulty apart from the lawyers.
But in
But
fact,
I am
in
not on that. Milord, if he wants.
in my court, I always extend time.
That would be your lordship's decision to do that because I felt very bad that the first motion can be taken only at 3:30. I felt that I should not have given the consent to the learned advocate.
It's okay.
I have learned
So
my.
tomorrow, list of both sides that will be represented to the respective learned senior counsel as agreed to by both sides, list on so and so. Tomorrow.
I have no problem.
Yes.
17.
Yes, we have seen that order.
Your lordships, I'm so grateful to the court, my lords. I just saw, my lords, in the homework, I did some more homework. My lords,
Yes.
may I just submit lordships, if you kind. My lords, the point over here is there that the ABL shipyard order of 3-judge bench of Supreme Court, which my lords have taken note of in one decision which my lords have passed. In that case, your lordships can see that order, Supreme Court order, that was during the, and though my lords asked me also, that it was during the course of pendency of the insolvency proceedings when moratorium was on. In my case, already the process of insolvency is complete, my lords, and moratorium is complete. The new management has taken over the company petitioner, and this writ petition is filed by the new company, my lords, new management. And the protection is taken under section 31, subsection 1, my lords, of the insolvency bankruptcy code, my lords. It says that once the resolution plan is approved, my lords are aware about it. So all the claims which are prior to the.
It will not be inherited by the new entity.
That is my case, lordship. Only that is my case, and that's why I was relying when reference to this honorable court, my lords. In the case of this Ghanshyam Mishra, that was all. Coincidentally, my lords, Ramana Saab's order is also 3-judge bench order ABL shipyard, and Ghanshyam Mishra by Justice B.R. Gavi's order is also by 3-judge bench. But in
ABL shipyard case, my lords, as I could understand, I was going through, there is no consideration of section 31 subsection 1 and Ghanshyam Mishra is nowhere cited also. I am only on Ghanshyam Mishra. That's my case.
Okay, then I'll issue a notice and then.
I'm so grateful, my lords, that you have given me so much patience.
In fact, the challenge is made to the assessment order, including assessment order. That was only based on, my lord, section 238 of the, my lord, insolvency code, my lord. So, my lord, we'll file a short affidavit, lordship, on the next date itself, your lordship may.
Till then, don't proceed with that.
Lordship.
What was the earlier entity?
My lords, the entity is Meghalaya Infratech Limited only.
No, the previous entity was same.
Same, my lords.
Same name.
Same name.
But it's now with the new management.
New management, Mr. Dhar, who's the director. My lords, can I have a list of dates for each of my lords?
Where is that?
That I give my lord. Sorry, I can give again. I have extra copy, my lords. I will give.
It's okay. Once you have given, it will be available.
3 page, my lords.
This
is a case law compilation, not 3 pager one. So that my lords can have dates.
yes.
So grateful.
Okay, you Mr. K. Goel.
Dear Lord, Kapil Goel.
And Mr. K. Goel and counsel for the petitioner. And Mr. S. Chetial and standing counsel for the respondents. You'll also be appearing for 3?
No, lordship, I'm appealing for 1 and 2, lordship.
1 and 2. Mr. Gogoi, Mr. Gogoi, as CGC you can appear for 3. And Mr. K. Gogoi and CGC appearing for respond for 3. Next, brother. Issue notice of motion returnable when?
2 weeks, lordship.
Returnable in 2 weeks. Requisite extra copies of the petition be served on the learned CGC and Department of Counsel in course of the day. Next paragraph. Heard both sides on the prayer for interim relief. So the case of the petitioner is that the Deputy Commissioner of Income Tax, Central Circle 1 within bracket Guwahati within bracket respond number 1 had issued an assessment order dated 29/3/2023 under section 153 capital C, read with section 144 of the Income Tax Act. Full stop. It is projected that the petitioner company had undergone corporate insolvency resolution process as per the Insolvency and Bankruptcy Code, 2016, and the petitioner number 1 company has been taken over by a new management on completion of the resolution process. Correct?
My lords.
Accordingly, it is projected that the liabilities which have been determined in the assessment order cum demand notice dated 29/3/2023 was for a period prior to the new management having taken over the petitioner number 1 company. And it is projected that such liability, if any, ought to have been determined. Sorry, ought to have been sent to the insolvency resolution. What do you call IRB?
Yes, my lords, insolvency plan, as I couldn't note.
No. What is it? Insolvency professional? What is it you call?
Resolution.
Resolution?
Insolvency resolution professional, IRP. Insolvency resolution professional.
IRP. The IRP, insolvency resolution professional.
Sorry, my lords.
And it is projected that any demand or liability which arose prior to the closure of the resolution process is deemed to have been extinguished. Where is that assessment order demand?
My lord, that is
Which
there.
period?
Your lord.
It's for 11-12.
For 11-12.
Your lord.
Okay.
2 years, my lords, 11-12 and 16-17. Both are
Okay.
prior to 2020, the resolution.
Okay,
plan.
it
That
is
is another case.
accordingly as it appears that the period of demand was for the assessment year
16-17 and 11-12, my lords.
11-12 and 2011-12 and 2016-17, which appears to be prior to the where is that resolution closure?
That is, my lords, dated, the date is, my lords, 6th March 2020 and approved by NCLT on 18th May 2020. First date,
6 March.
2020.
Oh, okay. The closure of the
I've referred page number also.
resolution process was by order dated 6/3/2020 by the NCLT.
NCLT date is 18th May 2020. This is a resolution plan date which is approved by NCLT.
Pardon me?
NCLT order date is, my lords, 18th May 2020.
So what is 6/3 is?
It's a resolution plan which was approved by
Resolution plan approved by
NCLT.
NCLT was on 6/3/2020 and the plan was approved by order dated 18/5/2020 by the NCLT. And therefore the assessment year being prior to the said dates.
1.1.
As an interim protection, the court is inclined to provide that the impugn ordered assessment order and demand notice dated 29/3/2020 shall not be put to execution.
So great, my lords.
List on so and so. This is till the next date of interim order till the next date of listing. Okay,
Deeply applied.
this is effective till the next date of listing.
Grateful. I'm so grateful to the court, my lords, for the indulgence.
19.
Same,
19
same,
same.
my lords, both are same.
19 is also same.
19
Dates are also same.
Assessment year 16-17.
Assessment year is 16-17, my lords. And that.
Just 16/17. The dates are same.
Dates
Same.
Okay. Okay.
so
Okay.
great, my lords.
Yes, Mr. Has.
But item number 25, my lord, it was supposed to be taken up to be my lord. By 11 to time.
Item?
25.
Item 25.
Yes.
So-
Yes. You're
That
calling
was by misplace in fact. So Lordship, here I have gone through, in fact, if I am being guided by that Annexa 8 and the subsequent representation that the petitioner has filed. So this Annexa 8 is the order passed by the Office of the Deputy Commissioner.
Yes.
So from here, I could gather that the petitioner already his lease period has expired. His lease period, and here he says that he has given up it on 6/6/2022. Thereafter, from 30/6/2022 to 29/6/2023. This is the period where the KISS money has been demanded of the petitioner, that is 11,86,000 and odd amount. So now the petitioner says that already, just because they have prayed for an extension of 3 years, that hasn't been granted. So they have refused, the society refused to take the extended period of 1 year.
They got it for 1 year.
1 year, but they have
But they said
refused.
that, no, but they said that the formal handing over was not made.
Handing of, but there has to be a gap period because he was continuously from what I can get from the going to the petition, he was continuously having the lease period. Subsequently, he has prayed for an extension. That extension
No,
has
but
been
you see,
granted.
Mr. Das is showing us a
So that-
letter.
Handing over report is nowhere found in the record, in fact.
No, in fact, what Mr. Das was showing
Yes,
is a direction to the deputy commissioner
yes.
to take steps for what you call physical handing over. That is what the Mr. Das showed us. Which page, Mr. Das? To hand over position. Yes, page 23.
Page 33, my lord.
Page 23 is second last paragraph.
Yes.
Here it says that
The Deputy Commissioner, Borpeta, will take necessary action accordingly for handing over token possession of the fishery. Token possession after completion of all required formalities as per the provision of the order is issued in, so this is order of 2021.
yes.
This is order of 2021.
So he says that he has never received it.
Whereas his lease period goes up to 2022. The last date, that is the order of the Deputy Commissioner. And in fact, if Lordship goes to the representation, in fact, the representation of the petitioner, he has addressed to the additional Deputy Commissioner. So here he says that the last date was 6/6/2022. If at all the last date is on 6/6/22, how can the handing over be taken prior to that? So for that matter, my specific instruction, whether the handing over process has been done or not, that need to be cleared before the court. So without that, obviously, if at all no handing over was done, he is bound to pay the kist money.
Yeah, my lord, that will be clear, my lord, from annexure 9, page 39, my lord.
Page
Page 39.
39.
The second paragraph, it appears that the present, that at present, the said fishery is not under operation since completion of regular lease on 6/6/2022. As the existing lessee was not keen to run the fishery for the extension granted by the government now. So this is very much clear, my lord. This is just to say their scheme, my lord, they have issued that demand notice, my lord, whereby we have been directed to make the deposit, my lord.
In fact, Mr. Barua is saying only that only.
Right.
You see.
On our
this-
extended, most interesting, my lord, on our extended petition, my lord, the deputy commissioner Borpeta was directed to submit a report, my lord. On 3 occasions, by 3 letters were issued to the deputy commissioner to submit a report.
No, your
On-
earlier
on-
period ended when?
My lord.
What is the date when your earlier period
Original
ended?
6/6/2022.
original lease period was from 25/6/2015 to 24/6/2022, my lord.
Just a moment. From when to when? Please come again.
From 25/6/25 to 2015 to 24/6/2022. That will appear, my lord, from annexure 1, my lord, page 19, my lord. Lease, that is the lease.
Okay. So second extension would come in the year 2022.
My-
Yes.
And you say that it was never handed over to you.
Correct, my lord. There is, my lord, that.
He says that it is not handed over,
Page
but
22, my lord.
from the demand note that has been sent across to him, it can be made out that he was continuously in the possession of the fishery.
Yeah.
If at all.
For 7 years
that
he
part
was. For
is
7 years he
definitely
was.
that little correction needs to be cleared from all sides so that I can come up before your lordship with the correct.
For 7 years he was.
He was there, but
But-
then again he prayed for another 3 years, but that
He
has
did
been
not get
only
it. He
reduced to
did not
1
get
year.
it. He did not get it.
Yes.
And therefore is not interested.
Yes, so may I, from going through the representation that he has filed before the authority. So this is the last page 43. It is respectfully submitted that number 1 so-and-so settled with so-and-so for the period of so-and-so. And his last date was 6/6/2022. So this is the contention of the
How
petitioner.
it can be, my lord, 6, my earlier period was up to 24/6/2022, my lord. As per the lease agreement, my lord.
So this is the contention of the petitioner. I am only relying upon his document.
So it
The
doesn't say that.
fishery was affected by illegal sowings, if I go down below, but on 10/3/2022, our Samabhai Society refused to accept 1 year extend lease period.
Yeah.
So they refused. lease period and filed an application before the fishery department when we gave up our possession of the fishery on 6/6/2022. So here it is his contention that they have given up. But where is the order to substantiate this fact that they have already handed over? We have taken?
Mr. Barwa,
Yes,
otherwise also on 24/6/22, the lease period ends.
that ends.
But
But
if, let us say that he doesn't give you possession on 6/6, on 25, otherwise also you will take over possession. It's a matter of 15 days. Nothing more.
But here from the demand note, it can be made out that he was in continuous possession. That's why that case money has been demanded of the petitioner. So in this
right.
respect, at least can a short date be fixed so that I can come up with a specific instruction?
Then don't recover the money.
Yes.
The last order I give to whom? I give a dictation. I give a dictation. Same order. Huh? Mr. Barma, when do you want?
Let it be any short date. This week also I can produce by Friday.
By Friday?
Friday, yes.
Okay. No, not Friday, we'll make it Monday.
Monday. Yes.
Friday 5. Notice returnable on 5. So that's having heard both sides on the prayer for interim leave. On a position made by London Senior Counsel for the petitioner that the periods of lease of the fishery in question was from 25/6/2015 to 24/6/2022, and that as per petitioner's representation dated 10/3/2022 within bracket Annexure 4, whereby they returned possession of the fishery to the where did you say you returned it? Which page? Which page was that? I was reading that you returned it, possession.
That is my lord. Page 23, my lord.
Huh?
Page 23, that is the order of extension, my lord. That is 17/12/2021.
No, that part we were
43.
reading.
43, the
Page 43, huh? Representation date 13/5/2023. That that 6/6/2022 was the last date of period of settlement.
Now, what if they got this date, my lord? Actually, origin as per the lease, my lord, lease deed, my lord, that period is up to 24/6/2020.
No, it is your representation, page 43 is your document.
There may be some maybe mistake, my lord. There may be some mistake.
I don't know, but it is your document. He's just reading that.
we have to believe that.
There may be some mistake, my lord. It cannot be, my lord.
No, I don't know, but this is what you are saying.
Absolutely correct.
This 13/5/23 is Annexure 11. And that the position of the fishery was returned on 6/6/2022. And in any manner, in any way, the period of lease, as per the petitioner, would have ended on 24/6/2022, till the next date of listing, proceed steps for recovery of the lease money would not be initiated against the petitioner. Next per list on 5/6/2023. Next per the petitioner shall produce a certified copy of this order before.
Well,
before whom? Certified copy of the order.
This additional deputy commissioner, my lord. Borpata.
Additional deputy commissioner, Borpata, respondent 4.
Obliged.
65 and 66.
Yes.
So far 65 is concerned, I highly apologize, Lordship. I was to file an affidavit
but due to this condition, landslide condition, petitioner is just reached lordship. We are just filing it
Okay,
and
so we'll take it up day after tomorrow then.
so Wednesday, then both the matters may be taken up together.
We can take it up Wednesday. Yes. All sides are duly represented. Mr. A. Varadarajan and counsel for the petitioner submits that the petitioner is filing affidavit in course of the day today.
Affidavit in terms of the order passed by the Honorable Court of the last.
In terms of order passed on 25/4/2023. Accordingly, matters stands adjourned today.
I am for the
Yes, sir.
response number 2, Lordship.
Okay, I've said all sides are represented. You want your name to be recorded, Mr. S. P. Chaudhary for the for respondent number 2 and Ms.
Miss Ardeka.
Ardeka on behalf for respondent number
Number 1.
respondent number 1. Okay. List on. Yes.
$67. May it please your lordship.
Yes.
But before I start,
Yes.
may I briefly indicate one thing? This matter, I got it on the production list by mentioning that it might become infractions. Positive time, first date gone. Second date, lordship here also gone. Third date, my colleague on personal counterfeit adjournment. If I am able to persuade your lordship for interim order and it's become infractious, status quo ante may be granted to that. I'll start. I strongly believe something has happened by this time. My lord, in a particular.
Somebody is trying to withdraw a complaint.
No, in a particular cooperative society, a fellow shareholder like mine had come to this honorable court saying that for the AGM election, the voter list is incorrect, it's faulty. This honorable court said that 2 days to go for election, you go to the registrar, the authority, election authority. Registrar would take your representation and after disposing it of, approval may be granted. He submitted his representation. Then got won away.
That much I understand.
Immediately we filed and said that please do not allow the withdrawal, please adjudicate. It was in these circumstances we had come to this honorable court. Because that was a right in them and that order of this honorable court neither was in review nor any appeal was passed. Today, Lord, he needs to submit. I do not know what is the stand there. If by this time something has happened, then Lordship will protect us. If not, may not let the.
No, because I was proposing to dismiss the petition. You see, for a simple reason. Number one, this is a cooperative society.
Society.
Correct. In a cooperative society, one person files a complaint. Correct.
Lordship.
Now, for whatever reason, he doesn't want to pursue his complaint. He wants to withdraw it. Correct. This is not a PIL where the court will continue with the PIL even if the petitioner withdraws in. You see, it's a right of a person to file a complaint and right of his person to withdraw it for any reason. He may be won over, he may have been threatened. Correct. He may have been intimidated and he has withdrawn it. But the right to withdraw is a fundamental right.
I thought over it. I actually thought over it. What had happened is that if we had simultaneously filed, I'll just elaborate. If we had simultaneously filed application with petition, this honorable court secured such an order, gone back, another one comes in, that would give rise to numerous
No,
proceedings.
you could have also filed a complaint. Your complaint is not there.
We actually.
You say that you don't allow others to withdraw the complaint. That is.
No, page 8, paragraph 8. We are not on that.
I find that preposterous. I may be a what you call pendulum swinging from here to there to here.
Page 8, paragraph 8. What is our case? Page 8, paragraph 8. We could have filed a petition saying that in these circumstances, we did a similar prayer. But since one of us had already gone there, an order was there. At the last moment, he tries to withdraw. Before his withdrawal, we submitted an application there. We submitted an application requesting kindly adjudicate the ordering them. Since they were not acting on that,
where is that complaint?
Page 8.
Page?
Page 8, paragraph 8 is our statement.
So that was an individual what you call complaint, correct?
He submitted 29. Page 29 is that.
You know, Mr. Banik, I'll just tell you one story. I'll not give the dates, otherwise you will understand for whom I am referring to. You see, Mr. Bhuya will just not hear it. You will be here, but don't hear it. You see, in a election petition, lawyer gave the name of various witnesses. The respondent is a winning candidate. The petitioner gave names of witnesses of all persons very close to the respondent. Correct. About 15-20 names were given, all very close to the respondent. And in the trial, he examined 2 or 3 of his own witnesses and never called for the others. And so far as respondent is concerned, the winning candidate, he never gave the names of any witnesses because all these witnesses were already cited. So he was very happy. And in the trial, this gentleman, what he does was, he does not examine any of the witnesses and the trial is over. Correct? I'm not giving the dates, otherwise you will be able to know it. So you see, when somebody is in court, it is the wittiest who will win. If law is not very, very strong on his part. So he has withdrawn, he has initiated a complaint, then withdrew it.
I understand.
And
That's
then
the precise point I'm making. That's the precise point I'm making. Page 8, paragraph 8.
No, I understand. But
That's the
what is
precise.
the remedy?
No, the sanctity of a court order remains. When I come to court, if this, I would bow down to that. I have to accept it, whatever Lordship says. If this be so, then we started from the same. He asked me, brother, I'm going to the court. I have an order of the court. I'm going there.
Right.
In the meantime, election is there. Approval is waiting, and he files application to withdraw. Prior to that, my application is prior to that.
No, I understand. You may have a good case, but you see, a fundamental right of a person to withdraw his complaint.
Regardless of the withdrawal, an honorable High Court, considering the facts and after hearing the inter-party order, after considering the both submissions, directed a statutory authority to perform a duty. This remains and this holds the field. It becomes an order in rem. In personam is only to the extent of his filing the representation. The order of the Honorable High Court and the order to be passed by the adjudicating authority are both orders in rem, because these would affect the election of the society. Me being a shareholder of a society had no business to come to the court when already there was an order of the court. That's why I can explain my standpoint. Now when he withdraws, I have nowhere to go. I come to this honorable to say, regardless of his withdrawal, let the adjudication be there. The election is over. There is no stay of that. Tribunal will only adjudicate on the voters.
Mr. Banik, I pose a question. It may be wholly inappropriate, but it's only an example, illustrative example. It may not be correct. Now you see, I understand somebody filing a plaint in the trial court. Correct. In appeal, it is adjudicated. In second appeal, he makes a prayer before this court that please permit me to withdraw the plaint. I can understand that proposition, it can be allowed. Correct. But in the progress of this adjudication, when the High Court sends the matter to the authorities to adjudicate, if at that time before the authority, which is the registrar of companies or any authority, if somebody withdraws the complaint, you see, there's a difference. What I'm trying to ask you.
I understand.
That withdrawal of the complaint itself is permissible.
Application of order 23 is by an order of the Honorable High Court.
No.
Independency of second appeal.
No, that authority.
No, in second appeal, the Lordship, what I felt from the Lordship, an application under 23 would be in the trial court first, if not in the second appellate court. In the second appeal, there's an order of the High Court, go and withdraw. The withdrawal is granted.
Plaint is permitted in the High Court.
Permitted. But
In
here,
second appeal.
it's the other way around. Just the other way around. Honorable Court said, all right, election to go, you submit the representation, the statutory authority to look into the matter, no approval. This is an order in rem, my lord. I would respectfully distinguish between the two. He is not withdrawing the writ petition. Had he made a prayer that I do not want the writ petition, whatever was there, he successfully grants an order. it allows the election to happen. We could not read the mind. We're not smart enough, my lord. We could not read the mind. That's why paragraph 8, I thought so this would come. Therefore, I came prior in point of time, my lord. At the earliest point of time I came, I approached the registrar. I came to this honorable court. I did not lose a moment when I could read his mind. And before his application for withdrawal was fine, I filed my application saying that please, regardless of that, kindly adjourn the High Court order for that. Where does a person go, my lord? I put that question to myself. I have no remedy left. And let my colleague say something else because he was a counsel. I'm not as a counsel, my lord. The board was the state was represented. Department was represented. Department knew about the matter. There's a High Court order. Writ petition was never withdrawn. The sanctity of the order remains regardless. And today is late in the day because 3-4 dates I have already missed.
This writ petition is closed.
Earlier, yes, it's closed.
No, it's closed.
My lord, paragraph 8, page 8, if I may read.
I've seen that. I've read it.
Because that is absolutely what happened. And now we are on, if you could be so smart, we'll also approach the same Honorable High Court and make the same prayer. And we had made a statement, we rely on all his statements and contentions in those writ petition. It may be tagged. We rely on that. The status of the writ petitioner and I, same. The shareholders. Had it been qua any personal relief, then I would have a different footing. His prayer, if allowed, would have a rem effect. My prayer, if allowed, same.
In a complaint, you can't be allowed to be substituted. That
No,
is
I'm
the
substituted.
individuality. Then who will pursue that complaint?
My lord, I'm not on this, his representation. That will be ministerial act, my lord. He is submitting a representation, not. There's a direction of the Honorable Court that authority would look into the matter and then grant approval. I say, regardless of any application, kindly look into the matter and then grant approval. There might be something because he had got on record documents to suggest correctness of things.
Under the Act, is a suo motu power available to the registrar to make an inquiry without a complaint?
No.
Then?
But since there's a direction of this Honorable Court, then may I pray for a direction, similar direction in this court, because I'm relying on his statements in these facts and circumstances. In these facts and circumstances, because we have not challenged the correctness of the voter list, because that was already adjudicated by the Honorable Court. Second time, we did not pay for the same relief.
No, we will give you liberty to withdraw it and to file a complaint.
But in the meantime, if any order is passed, I do not know. 3-4 dates have gone.
No, definitely it has been passed. We'll presume that it has been passed.
Then status quo ante, So he has to concede to that. I got it on the production list. I got it on 19th. Did not reach.
No, that is that
22nd
can't be
did not
granted.
reach. 24th he took time.
That can't be granted.
Then it becomes infracted by the day, perhaps. That protection what she may give.
Because
If the approval is granted and
if the complaint has been withdrawn, we can't give life to that complaint and,
No.
allow the authorities to make an inquiry as if that was
Lordship may
valid.
consider this my document, which we had filed. That was already there before the minister. That is page 31, 13th of May.
Just a moment.
Sorry.
Yes.
Page 31, that's 13th of May. That's our application. And his application is page 36, that's 17th of May for withdrawal. We indicated way earlier. Our document was there on record, but we are not supported by but protected by any order of the court.
But with that, you see the operation of law sets in. There's a bar of election within 6 months. What is that provision?
41. That could come in on holding of the election. But there's a judicial order saying that adjudicate election, the statutory authority to adjudicate on the correction of the voter list and then give the approval. Election was never stayed. Election is on. It's over. Those persons who are disqualified cannot come. I would not elaborate on that because I have not pleaded in detail. Because they're already in order of the Honorable Court. I pray, my lord, this is a situation when they're absolutely outsmarted us.
Yes, Mr. Taludar.
My lord, in fact, the application for withdrawal that has been accepted, my lord, an order has been passed.
No, what about the other player? What about the other player, Officer Banik, that the present complaint can still be inquired into?
It is prior intact.
The present complaint can still be inquired into. In this respect, what do you say?
In fact, the order which was passed by this honorable court, that is on 8.5, page 25, man.
Yes.
Page 25, and the operative part, your lordship will find in para 4 and 5. I think that remains, my lord. Lordship will decide, my lord.
This order is inherently wrong on facts. It says no petition was filed with 11/5/23 to 13/5/23. Our letter was filed on 13 May 23.
You are reading where?
This order, which presides.
Oh, okay, no, I'm not that.
4 and 5, para 4 and 5, page 27.
27.
27, 28.
Just wrong.
There are some directions, my lord. Can you give it to Mission?
No, I wanted to know
Otherwise,
the law.
what I'm
No, I wanted to know the law. Is in fact, let us assume that the meeting was held and approval was granted.
My lord.
Correct.
Right.
The question is, after the approval was granted, what is the remedy available to someone who says that that there are the elections were wrong or that the voters list were incorrect? What is the remedy under the act?
Act, my lord. In fact, there is a rule, my lord, election rules 2019. That rule has been, my lord, in fact, not quoted here, but it has been referred to Rule 27. Rule 27 says the election authority, that is the registrar, my lord, he can make an inquiry.
So he can still make an inquiry.
Yes.
That's what.
Even in this representation, he can still make an inquiry.
Yes.
And the 26 May 23, order having been placed before this honorable court, taking a judicial notice of it, lordship may not.
Status quo ante will not grant, but will direct them to make an inquiry.
But so far as 26 May 23 order is there, lordship may kindly have the document which my friend has placed, The inherent defect is there, 26 May 23 on a fleeting glance. The second paragraph, no petition, lordship is there. No petition was received between 11/5/23 to 13/5/23. Stop. I'm on that. Page 31 now, madam. Page 31 of a writ petition. Page 31 of a writ petition. That's our document on 13th of May. On the next page, But this we had filed on 13. We had filed on 13. The order says no petition was received between 11/5/23 to 13/5/23. It proceeds on a premise that we had never prayed. We prayed.
No, this order was never passed in your regard.
It says no petition was on 17/5. He pays for withdrawing.
He'll be definitely referring to only Alkas Din, no, not your complaint.
In fact, he had filed, madam. It appears.
He filed appeal. He filed on 12th. He filed on 12th. That's page 29.
We don't only seal whose signature it is. Very difficult to understand.
Anyways, brother, he withdrew, and they acted on a withdrawal. It's like the witnesses,
No. He's right. You see, their language may be incorrect, but he's right.
He's right.
He's right because in the first paragraph he says,
Correct.
I could ask him to give a representation of between 11 to 13. It was not done. It's not wrong.
Well, the gentleman who filed the earlier petition was very smart, Lordship protects us. Let no effect be given to this order. let them consider our what we are there
Mm,
in terms of the
okay.
early High Court order. That must be, because he has placed an official document before the court.
Heard. Mr. S. Banik, and counsel for the petitioner, and Mr. S. K. Talukdar, learned
I'm for
standing
respondent.
counsel for the cooperative cooperation
Well,
department.
one
Appearing
to-
for
1, 2, 3, 4, my lord.
respondent numbers 1 to 4.
Yes. My lord, only respondent 3 would be RK, my lord, RK Nagar, Assistant Register Cooperative Societies, RK Nagar. From other documents, my lord,
According
this
to
RK Nagar, my lord, Cooperative.
No, it's not Karimganj, it is RK Nagar.
Yes, Ramkrishna Nagar,
it is in Karimganj, I believe.
Ramkrishna Nagar, Karimganj. RK is missing, my lord. RK
He says
Nagar is
Ulubari,
missing.
Guwahati.
Okay.
RK Nagar, Karimganj.
Next paragraph. The learned standing counsel for the respondents is number 1 to 4 is submitted that the appropriate address of respondent number 3 would be the Assistant Registrar of Cooperative Societies, RK Nagar, Karimganj.
Fine.
So the learned counsel for the petitioner shall make necessary correction in the cost title before the registrar within bracket judicial. Next paragraph. Pending necessary correction of the cost title, I should notice a motion returnable in 4 weeks. How much time? 4 weeks or shorter date? Make it 3 weeks.
Yes, as per
3
lordship's
weeks.
convenience, I don't have any problem.
Requisite extra copies of the writ petition be served on the learned standing counsel for respondent numbers 1 to 4. Petition shall take steps within 2 days for service of notice on respondent number 6 by registered post with AD. Next paragraph. Heard both sides on the prayer for interim relief. Next paragraph. Learned counsel for the petitioner has submitted that initially the respondent number 5 had made a complaint against the election proposed election which was held
To be held then.
to be held in respect of Gandhigram Samavaya Samiti Limited, Karimganj, and thereafter approached this court by filing WBC
2439.
2439 of 2023. And this court, by order dated 8/5/2023, directed the respondent number 5 to submit a representation before the registrar of cooperative society between 11/5/2023 and 13/5/2023. And it was provided that till a decision is taken by the respondent number 2 with regard to the grievance of respondent number 5 in his representation, the AGM of the elected body will not be given the seal of approval by the respondent numbers 2 and 3. And the departmental officers would run the society till a decision is taken by the competent authority. First of all, it is submitted that the respondent number 5, instead of filing a representation in terms of the order of this court, withdrew his complaint and accordingly on voluntary withdrawal of the complaint, the Registrar of Cooperative Societies Assam held that the AGM of Gandhigram GPSS Limited held on 10/5/2023 is considered to be held in accordance with the Act and rules, and directed the Assistant Registrar of Cooperative Societies, RK Nagar, within record respondent number 3, that equals to accord approval to the proceedings of AGM as per section 45 of the Assam Cooperative Societies Act, 2007. Thus, it is submitted that the respondent number 5 by filing his complaint and approaching this court had prevented the petitioner from exercising from registering his complaint, and accordingly it is submitted that the petitioner has now submitted a representation before the Registrar of Cooperative Societies within on 13/5/2023 within bracket annexure E, alleging irregularities and illegalities in the preparation of voters list, and thus question the elections held in the AGM held on 10/5/2023. Next, accordingly, the court is inclined to observe that the pendency of this writ petition shall not be a bar for the respondent number 2 and 3. To inquire into the complaint dated 13/5/2023.
My lord, inquiry can be made by registrar only. Election authority is the registrar.
Respondent
Only
3,
two.
not 2.
Only two, my lord.
Only
Three.
2.
Not 3.
Only 2, okay. Respondent 2. 2 is the Assistant Registrar of Cooperative Society.
He may not grant approval, my lord. After the registrar's order, she may grant approval.
Oh no, Mr. Manik, we can't give that interim order. It will not be in consonance with the prayer in the writ petition.
Because after 3 dates, the matter
No,
not taken up.
it's okay, but you have to amend it now. It would be better if you get it amended and brought it again. If that is your prayer, because that can't be made. It will not be in consonance with the prayer. And in a writ petition, I can't digress against the prayer made.
But Lordship can always mold the relief. Since he has
No,
got this document by the official copy.
Molding relief is something which must be within the scope of that.
I could not have time travel with the
No,
document.
that's okay, but we'll permit you now to amend it. That
Better
prayer-
I withdraw and refile.
It will take you again time. Filing is again not a very easy task.
To file an amendment application, that will be allowed, then I have to refile the petition.
No, we'll permit you to amend the prayer if otherwise your statement
hand.
is. Have you made any statement here with regard to that?
This 26/5/2023,
That complaint which you have made, there's a statement there.
yes.
So you will permit you orally to amend your prayer. You
By
permit
hand.
that, and
Well, Lordship,
don't write all this. Huh? both sides are represented. I'm gonna just give the name, Mr. Manik and it is submitted that the respondent 5, after obtaining order dated 8/5/2023 in WBC 2439 of 2023, has withdrawn his original complaint before the Registrar of Cooperative Societies, Assam, which has which is not being anticipated, had dislodged the petitioner, and therefore he prays to permit him to amend the writ petition, amend the prayer made in the writ petition. Correct?
To the extent the challenge of 26/5/2023.
To the extent. No, whatever you do, I'm not saying anything.
Without that observation, challenge may be anything. It must be limited to some deliberation. of this
Okay,
court proceedings.
to challenge the
Order dated 26/5/23. So
Twen-
produced by Mr. Aludar.
26/5/2023. No, this you can't challenge. We are permitting you to pursue your own complaint.
Even if I, subject to correction, even if I rephrase my prayer and make it prayer that I may be allowed to pursue my own complaint, that document having been already annexed to the writ petition, Lordship may also direct, if I'm able to pursue the Lordship on the same page, that they act upon it. Regardless of this document, this order 26/5/23, because he has placed it now.
No, that was the basis of original complaint, that I'm not prepared to do it.
Then Lordship will direct them to act on the complaint 26/5, this 13.
That is not your prayer. That's what I'm saying. You'll have to amend that prayer. You'll have to
By hand.
insert it by hand. So as to enable the petitioner to pursue his complaint dated 13/5/2023, submitted before the Registrar of Cooperative Societies, Assam. So prayer is allowed. The amendment to the prayer shall be made in the presence of Registrar Judicial, and thereafter the matter be listed in the motion column.
If notice of motion goes only.
No, after notice of motion, I can't simultaneously allow you that, what you call the,
Then it comes after 3 weeks, maybe.
no. It doesn't come after 3 weeks. I'm withdrawing that earlier order.
That one.
Otherwise it will not list in motion column.
The first part has to go.
My lord will say, my lord, I have placed it on record, 26/5/23 of the order of the
Okay.
registrar.
Next page may be mentioned that the Mr. S.K. Talukdar, understanding counsel for the Corporation Department, has produced a copy of order dated 26/5/2023, which is made a part of record,
Passed by the registrar.
passed by the Registrar, Cooperative Societies. Okay.
God bless.
My lord will fix it.
I'm not saying you can do it tomorrow and get it a day after tomorrow.
We'll get it mentioned. Grateful.
Oh.
68.
Yes.
Wait, please. There are.
Mr. Sheikh, we can't do anything about it. A marketplace can be regulated.
Marketplace can be regulated. That is within their jurisdiction. But your lordship would be pleased to see the notice. That is at page 42.
They want you to be out of the of that market, because since there is a market already, they are asking you to.
There is a fishing market, my lord. We are traders, my lord, on trading license. Trade license is there in our favor. Without cancelling that trade license, my lord, we have been said that you go away. Under which provision that notice has been issued, madam.
No, you don't have a place of business. You are just occupying the road.
No, my lord, no, that is not the road. That is not the road. Your lordship would be pleased to see.
Where is
Please
it?
hereby inform you that you are doing business in front of newly constructed fish market of the municipality. It
Yes.
is newly constructed fish market, and we are doing our trade before the fish market, my lord. And your lordship, this is the notice. And now your lordship would be pleased to see the agreement, my lord. Your lordship will turn to page 38. Page 38. my lord.
Just a moment. Yes, page
Page 38, my lord.
38. I'm there. Okay.
Yes, for construction of new hygienic fish market at Abhayapuri by Department of Fishery, Assam government, your shop will be temporarily displaced. After completion of construction of aforesaid fish market, provision will be made for your re-establishment. But temporarily, we are shifted, my lord. Two petitioners were shifted, others were there. There was no shifting, and thereafter, my lord, nothing has done. And now this notice has been given me. And now your lordship, I am leaving. Draw your lordship attention to page 14.
Where is the statement that they have not given you alternative site?
My lord, that I have stated. My lord. I'm giving.
But Mr. Sheikh, I'm finding some difficulty in following it. You see, this, what is proposed is a fish market, right?
My lord,
What is proposed is a fish market.
my lord.
There are some documents somewhere showing that it's a somebody is selling vegetable.
Vegetable, my lord. No, my lord. Outside the fishing market, well, market is there. And we are doing our business outside the fish market. We are not doing in the fish market.
No,
Fish
but that can't be
market area,
permitted.
outside the,
No, that
outside
can't be
the
permitted.
market.
You see, that can't be permitted.
Well,
That is what is happening in Guwahati. Every
Well,
road has become a fish
not-
market or a
not
vegetable
on road,
market.
my lord. It is municipality area, my lord. Trade license is specifically said, my lord. The trade license, your lordship will see at page 14.
Just a moment.
This trade license issued
Just a moment.
under section,
Give me 5 minutes.
my lord. 299. 229.
Yes, where is the trade license?
Well, a trade license at page 14, my lord. Section 229.
Page 14, yes.
Yes, my lord. This trade license issued under section 229(1) and 231. 229.
So who are the persons having trade license?
My lord, 4 persons, my lord.
4 persons have trade license.
Three persons, I'm saying.
3 persons. Who are they?
The petitioner number 1,
Petitioner number 1.
yes, then petitioner number 5. Petitioner number 2.
Five.
And my lord, others applied for trade license, but it is not issued till date. And now your lordship would be pleased to see, they are collecting rent, my lord, from us from long time.
Oh, that they do from everyone.
My lord.
That they do from everyone.
So, my lord,
Even in you know, in Guwahati, all these vegetable vendors, from them the GMC collects parking fees.
Yeah.
They don't give receipt otherwise. You go to any vendor, ask them what tax you pay. He'll show you a parking fee receipt.
well, actually, what your lordship give an example of Guwahati. That is not the case, because my lord, we are about 30 years staying in Abhayapuri Municipal Board area.
You see, in Sunday,
And,
it took me
they are-
about 45 minutes to cross that Bertola market area.
Complete
Right.
road has been abandoned with all.
I just don't know.
No
And
one can-
everybody sees it, but everybody, what you call, sees it. But in fact, nobody saw it.
Very true.
I don't know how it can be tolerated.
Your lordship,
In Fishery, now you can't go.
if we violate any.
You have to take
provision of
extra
the
time
trade
and then go.
license,
This is destroying the every fabric of the city.
my
Everything. In fact, Lordship,
Flat, my lord, at this stage. my
Lordship,
lord,
he has referred to that trade
notice, no, my
license.
lord, what is
Trade
the stand
license.
of the
To those
municipality?
people who have trade license, will
So he
protect.
has referred to
Voilà.
the trade license which has already expired in March 2020.
No,
And
my
this,
lord, we applied for renewal, we
so he
stated.
doesn't have a license
That
as
is-
such.
that is not
And that
given.
apart, this market
No,
is
that is not
only,
mentioned.
No, you see, one doesn't have a trade license, you can stop it,
yes.
correct?
Yes.
But that power is not exercised. He says that you go away from this place.
My lord.
That can't be done.
He has been asked to move away from the newly constructed, hygienically built. fish
Where we
market.
will go, my lord, that is the point.
That is,
But if he has a trade license, where he will go?
We are
but
50
his
businessmen.
trade
my lord.
license
Where
has
we will go?
expired.
So that is okay.
His trade license has expired in
No,
2020.
but
That is not
no,
mentioned.
but
here.
your what you call this board is not stopping them because of that.
Yes. That reason has been cited otherwise because
Reason
it
is
is because
otherwise,
of
so
the.
you
Nobody
newly
could have
constructed.
decided.
You'll protect them at least.
In
At least
any case, I'm not representing the board at the moment.
two of them will
Let
protect.
the board come and say, my lord. what
Two
is
of them
the-
will protect, but not the others.
My lord,
Two of them will protect who have the trade license.
my lord, 2, 3, my lord.
No, you
One-
said only
one,
1, 3,
two-
and 5.
1, 2, and 5.
1, 2, and 5. Okay,
3.
okay, 3 people. Okay, we'll protect them. Heard. Mr. M. A. Sheikh, learned counsel for the petitioners. Also heard Mr. S. Barwal and the government advocate appearing for respondent number
Respondent number 1, 4, and 5.
1, 4, and 5. Next one. Agreed by the notice issued by the Abhayapuri Town Committee to the petitioners to vacate their they vacate the place from where they are doing business in front of the newly constructed fish market. The petitioners have opposed this court by filing a writ petition under Article 226 of the Constitution of India. First off, the learned counsel for the petitioner has submitted that in this writ petition, he has filed trade license in respect of petitioner numbers 1, 2, and 5. And it is submitted that the
My lord,
petitioners.
I may be excused, my lord, your lordship will come to page 38. There is an agreement with petitioner number 3, that alternative side will be given.
Where petition number 3,
3, my
Page-
lord, page
page?
38.
38. Okay, it is also submitted that insofar as petitioner number 3 is concerned, there was an agreement between the
Chairman and
petitioner and the chairman of Abhayapuri Town Committee dated 8/3/2017, whereby his shop was displaced with an understanding that on construction of the market, one room would be allotted to him. First of all. Make these two together. So, therefore, writ petition under Article 26. Next para. Issue notice of motion returned by the insolvency.
4 weeks.
Requisite extra copies of the writ petition be served on the government advocate. So the petition shall take steps for service of notice on respondent numbers 2 and 3 by registered post with AD, and in addition, petitioners will serve notice on the said respondents by routing the process to the registry of the court, and upon service and affidavit of service shall be filed prior to the next posting. Next paragraph, till the next returnable date, comma, in view of the documents produced by the petitioner numbers 1, 2, 3, and 5, comma, the Abhayapuri Town Committee representing of respondent numbers 2, 3, and 4 shall not evict the petitioners without following due process of law. This is till the next date of this, there will not be this is due process of law. Next, the petitioner shall produce a certified copy of this order before whom, Mr.
Chairman.
Before respondent number 3 to bring the order to the notice of the said authority. Okay.
Petitioner number 2, 1, 2, 5, and 3 protected.
Yes.
Item number 10, timely.
Yes.
Small issue is involved here also.
Head perception.
Lordship. That's only thing, your lordship,
Who threatened you? Where is that?
that my FIR, your lordship, is there. Intimation to the authorities. Page 39, your lordship. Now, your lordship, I was interested to work. your
Just now. Some wrong. Ah, yes. Where is your FIR?
FIR, that is at page 39, your lordship.
39.
That is below is the receipt, your lordship. These laborers, your lordship, who were disturbing, your lordship, they belong to the.
You're not named anyone.
No, your lordship, there are large number of your lordship workers, your lordship. So
No,
they
but
are
this
not.
is something which is not permissible. You see, for example, every person coming, you'll lodge an FIR that I have been threatened, and the state will have to give protection to everyone.
No, that is not everyone, because your lordship, here what has happened, your lordship, the work has been awarded to me, your lordship. Now, when I went there, your lordship, with these workers, your lordship, my laborers, your lordship, I have not been allowed to enter by these miscreants, your lordship. That is the problem, your lordship.
No, but what will Supreme Police do? You'll have
No,
to ask
until
the
and unless police
railway authorities of that railway station
Lordship.
to allow you to enter. If they don't enter, because the railways have their own police force, railway police
Not
force they have.
railways, your lordship. It is by the, ultimately, it is by the.
FCI.
FCI. Your lordship. And we have informed them, your lordship. People in charge, your lordship. That was the problem we are facing, your lordship. Ultimately, your lordship, we have quoted a rate and a tender has been awarded, your lordship. In the process, your lordship, I have also deposited earnest money, your lordship. And I have invested, and then.
Who's appearing for FCI? You're for FCI?
Appearing on behalf of BKC. Appearing on behalf of BKC.
Please ask Mr. BK Singh to be here. We'll ask him some questions. He's available? He's in
He
court.
was, your lordship, he is
No.
probably, he had to leave,
He's absent.
he had to leave, your lordship, because
He's absent.
he will be leaving for ownership. That's what he told my. Or your lordship may fix the matter on Monday, your lordship.
No, because here we'll have to understand the FCI stand.
Lordship.
Mr. Gogoi,
Lordship.
I think there are certain things you may not know. But Mr. Bhattakur is supposed to know why you have appeared. I don't know in this matter.
But your lordship, so far as this demand.
It will be conflict of interest.
Lordship.
No, definitely it will be, because what I'm going to say will be a conflict of
As
interest.
for the contents of the lordship, page 39, it will be conflict. But my brother is always standing, lordship.
Yes, that's why I said it's a
Lordship.
conflict of interest. But Mr. Gogoi,
Lordship,
I'll tell you something.
lordship, lordship,
This is an inquiry you can make at your end and you will come to know.
lordship,
Labor Sardar
lordship.
in FCI would be earning 5 times the salary of your regional manager.
Lordship.
The FCI regional manager,
Lordship.
supposing we'll assume that his salary is 3 lakh rupees.
Lordship.
So this labor, what you call this, Sardars,
Lordship.
would be earning not less than 12 to 15 lakh rupees.
Lordship.
And this is what they are trying to say, that per bag so and so,
Lordship.
it's an extortion racket going on.
Lordship. Big racket is going on, lordship, other essential lordship.
It's a big racket. So we'll take it up on Monday. In the meantime, you inquire with the, ask someone in the police, which is this place?
This is your lordship, B. Courier, North Lakhimpur,
In Narayanpur.
Narayanpur police station.
Narayanpur police station. Just try to make an inquiry,
Lordship.
discreet inquiry,
Lordship.
just for your own knowledge,
Lordship.
what is happening in fact.
Lordship, lordship, I'll do, lordship, I'll do.
Okay, so it is submitted that all sides are represented. Miss B. Bharat and a council has submitted that standing counsel for respondent numbers 5 and 6 had to leave court for some personal work. So accordingly, the matter stands adjourned today, based on Monday, 5/6/2023. Next, in the meanwhile, the standing counsel for the FCI, respondent numbers 5 and 6, and the and Mr. K. Gogel and government advocate shall try to get some instructions in the matter.
Deeply obliged.
That's why I said, what I'm saying will be in conflict of interest.
We cannot stand for illegality. What they have done, your lordship, it is illegal. If someone getting a work, your lordship, by putting certain rates, he has the right to bring the labor.
You see, Mr. Chaudhary is political, was a political person. So that's why I said he was. Therefore, I'm telling you a story. Very respectable politician in Bihar. He was a union leader. And when this company could not tackle him, the industrialists in that area made him stand for an MLA, and he won and he became a minister. Correct. So to remove this labor from site, they had to make this man a MLA. Correct. He became a minister and he thereafter made a name of himself. So you can just
after this metric exam, this result after coming in the result file, somebody told that more the students are coming up with high marks, who will remain for politics one.
So I've given you a hint. You take a call now.
So I think motion already over, my lord.
No, one is left out, 12.
I pay my lordship, I think up is around 12 million.
On
12,
12,
by the time I'll have done something.
because
It will be in the motion stage, my lord.
then I'll issue a notice. Because
Not
uh, because then I can issue a direction that it will not be a bar for them to permit this portal to be
Yes,
open and
yes,
registered
yes,
for so far the petition is concerned. At the motion stage, I can't give her that relief.
not.
For Ms. F. Ahmed, learned counsel for the petitioner, and Mr. B. Gogoi, learned standing counsel for the
PWD. PWD.
for the PWD,
Madam.
appearing for all the respondents. Next para. The case of the petitioner, comma, in brief, is that his father was a class 1A contractor, and what is the date of death? Acha, and he died on 18/5/2021 after completion of construction. After completion of the construction work, and during the construction work of package number AS 23-332, comma, AS 23-344 and AS 23-276 for construction and maintenance of rural roads under PMGSY in Tinsukia district. But during the continuance of the maintenance work, full stop, it is projected that as per clause 55.2 of the contract agreement, it was permissible for the legal representative of a deceased contractor to complete the works. Full stop. The grievance of the petitioner is that although he is carrying out the maintenance work for the 3 rural road projects, but the respondent number 3 has not uploaded the profile of the petitioner in the E-Marg portal, correct?
Yes.
Lordship.
E-Marg portal. Full stop. It is submitted that it is submitted by the learned counsel for the petitioner that because of non-NON uploading of the profile of the petitioner, comma, the work carried out by the petitioner could not be recorded. Accordingly, it is submitted that the work done for last the work done since 18/5/2021 has not been registered in the E-Marg MARG portal of the PWD. PWD, right?
Lordship.
Next paragraph. Accordingly, the petitioner has filed this writ petition in Article 226 of the Constitution of India. Next issue notice of motion returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned Department of Counsel in course of the day. Next para. Having regard to the nature of grievance raised by the petitioner, comma, the court is inclined to pass the following orders. Number 1, that the pendency of the writ petition shall not be a bar for the respondent authorities to examine the claim of the petitioner and to upload the petitioner's profile in the E-Marg portal. Number 2, if for any reason the profile of the petitioner cannot be uploaded in the e-mark portal, the concerned respondent authority shall receive a physical copy of the document submitted by the petitioner by giving acknowledgement. Next, the petitioner shall produce a certified copy of this order before
Chief Engineer. Respondent number 2.
before the
Chief Engineer.
Chief Engineer PWD.
Lord,
Respondent number 2.
Respondent number 2.
No, because 2 and 3, make it 3 also.
Lord.
Make it 3 also, because this
Yes.
receipt will be done by whom?
Yes.
Physical copy will be-
Otherwise, someone from the office of the Chief Engineer will do. So let it be 2 and 3.
2 and 3.
Yes.
2 and 3. 3 is Executive Engineer PWD,
Lord.
Digboy and Margarita Territorial Road Division, Margarita, page 3.
Lordship, it is respondent number 4 that will upload the profile of the petitioner in the e-mart, Lordship.
No,
Not the
for then
respondent
it is
number
2 and 3 will decide, my lord. Without their instruction,
Okay.
probably, yes.
Okay, let them do it.
Lordship.
No, list on so.
The-
Production list item number 1.
This IA, my lord, we have filed, my lord. My lord may kindly peruse the order dated, my lord. 24-3 at page 11, my lord.
24-3.
At page 11 of the IA. my lord. My lord, in this order, my lord, we were the earlier settlement holder of the market, my lord, for 22-23. We were to collect the toll from the shopkeepers. There was resistance by the shopkeepers, so we had filed this petition before the expiry of a period. And there was an order at para 6, my lord, on page 12. That it is observed that during the pendency of the petition will not be a bar for the respondent authorities to take the representation dated so and so on board and to consider the same for redressal of grievance expressed by the petitioner there. So we have sought under the Municipal Act under 148(3) there is a provision for extension. And we had also in the repetition prayed that no NIT may be issued till the determination of this issue. Thereafter, my lord, at page 14 is a subsequent order passed in the repetition, my lord. Notices were served upon respondent number 4 and 5 and also on the market committee. And they have, as on date, they have not appeared. And the state councils were directed to obtain instructions, but they have not received the instructions. And at page 15, my lord, is important, my lord. It is stated
Just a moment.
the senior counsel for the petitioner at page 15.
No, just a moment. Yes.
Page 15 of the IA, my lord. Learned senior counsel for the petitioner submits that there is a contemplation for initiating a fresh tender process in which the petitioner may suffer prejudice. In view of the above, the aforesaid submission would be considered at an appropriate stage. So this order was passed on 19 May. Thereafter, my lord, a notice has been issued on 28th of May, fixing the last date of submission on 29th of May, my lord. So in that view of the matter, we have filed this present interlocutory application for suspension of the NIT, my lord. Because we have invested a huge amount of money, my lord, around 40 lakhs were 4 lakhs were invested, my lord. 4 lakhs 19,000 were invested by the petitioner, my lord. And moreover, there is a clause that the government can decide for extension for the period, my lord. Or they can return the money, my lord.
No, what is your right to have your what you call the market extended?
Because, my lord, we could not operate that period for the period.
You can ask for a refund.
But we had out, but there were no instructions from them because now if the NIT is floated and the third party right is created, it will lead to multiplicity proceedings, my lord.
No, your right to refund is always independent.
And moreover, my lord, there is a provision under 148(3), my lord, they can go for extension also. So before our expiry, we had raised that plea, my lord.
No extension. Why should the court order an extension?
Because and they had sought for
Right to competition would be taken away. We can merely say that
But
you
let
can
it,
pursue a
because the
claim for
main case is
refund.
fixed on 9th of June, my lord. I pray, my lord, let the status quo as on today be
No, no, not,
passed,
not,
my
not for
lord,
tenders,
because,
not for tenders.
or they may furnish instruction as to whether,
No, Mr. Khan, in the main writ petition, your prayer is to direct the respondent either to refund.
no, yeah, also
So
in
once
the
once a refund is paid for, then you don't have a right for an injunction.
refund or for extension, my lord.
When relief can be computed in terms of money, you don't get an injunction.
And my lord, I also prayed for in the interim that not to issue any NIT for the year, my lord.
No, no. You'll permit them to do it and you'll have to claim your refund. You say that you're not been able to
Yes, my lord, we have
to,
made a statement, my lord.
what you call to operate the market.
Yes, my lord.
Correct.
Yes, my lord.
It is from which period to which period?
From 22 to 23, my lord.
22 to 23.
Yes, for a period of 1 year.
What is the ground you could not operate?
My lord, there was obstruction created by the shopkeepers, my lord. And in fact, the municipal board also had requested the shopkeepers to pay the amount to us, my lord. At para 11 of my writ petition, I have made a statement, my lord, that the municipal board asked the shopkeepers to pay the toll to the petitioner, my lord. But even then they refused. And my lord, there's a provision that the municipal board, they can exercise powers under 148, my lord. In fact, using police force also, my lord. When the municipal board at page 41 of the writ petition, it had requested the shopkeepers, shop owners to pay the toll to the petitioner, my lord. Even in spite of that, it was not paid.
No, then you have your refund. Because Mr. Khan, I fail to understand. You see, if you can't collect toll, why you need an extension?
Because the investment which I have made, if they make a
No, but it's okay. You're not getting a toll. Why would you seek an extension?
Here, my lord, we have received an instruction, my lord, why he has not collect that toll, because my lord, he is demanding more toll from the vendors, my lord. That is our instruction, my lord.
Maybe some reason has to be there, because if I'm not getting any payment, why should I ask for extension?
Let
It
them
is
furnish the
it's
instruction.
a counterproductive.
In the meantime, my lord, I pray, my lord, because the main case is fixed on 9th of June, my lord.
No, I'm not extending that the tender process. I'm not staying.
Yes, ma'am.
It loses what you call opportunity of competitive bidding. If they are not giving toll, good riddance. Or Mr. S. Count on counsel to the applicant. And Mr. M. Cherial, and government advocate appearing for us for opposite party members.
Submission, my lord, in that case, my lord. Let them decide about the refund part, then, my lord.
That will make
1, 2, 3, and 7, my lord.
opposite party number 1, 2, 3, and 7. And Mr. For municipal board, who's appearing? Karimganj Municipal Board, no one.
Municipal board, my lord. No, they have engaged an individual council, my lord, elected body, my lord.
Notices were served, my lord, on the last occasion. The Lauzima report shows at page 14, my lord. This service is complete upon 4, 5, and 8, my lord.
Okay, none appears for opposite parties number 4, 5, and 8. as it appears from the order dated 3/5/2023 passed in the proceedings of Lavazima Court in the connected rate petitions. Next para. This interlocutory application has been filed by the applicant, who is the rate petitioner, with a prayer to stay the impugned auction notice. It's an auction notice or something?
Yes, madam.
Notice inviting tender dated 20/5/2023 for settlement of the which market?
Ramoni Mohan Municipality Market, madam.
Ramoni Mohan
Under Korimganj
Municipal Market under Karimganj District. RAMONI Mohan MOHAN Municipal Market. Next para. The learned counsel for the applicant has submitted that the applicant is the lessee of the said market for the year 2022-23. It is projected that during the said period, the traders of the said market had refused to pay toll to the petitioner, for which the petitioner could not run public operate the said market. First one. It is also projected that the petitioner, sorry, the applicant has moved the respondent authorities for refund of a sum of rupees 4,75,000 to the petitioner, along with the interest and compensation for not being able to operate the said market. In the rate petition, the petitioner has also made an alternative prayer to allow him to operate the said market for another year 2023-24 in terms of section 148 within bracket 3 of the Assam Municipal Act 1956 in lieu of money deposited in the year 2022-23. Next paragraph. The learned government advocate has submitted that as per instructions received by him, the traders of the said Ramani Mohan market the Ramani Mohan Municipal Market had refused to cooperate with the petitioner as he was seeking more than the prescribed toll.
Yes.
Next paragraph. Be that as it may, the stand of the respondents being not made by filing an affidavit, the court cannot take cognizance of such of the submissions made by the government advocate. Next paragraph. Nonetheless, the court finds that as one of the prayer in the rate petition, connected rate petition is for refund of the money, the court, in the considered opinion of the court, the petitioner would be descended to any interim order. Moreover, if the case of the petitioner is that the traders of the said municipal market are not cooperating with him by paying the toll. Or the court finds no reason for the petitioner to seek an extension of the period of lease for another year. Next, accordingly, on both the counts as mentioned hearing before, the court does not find the petitioner to be entitled to an interim order for deferment of the tender proceedings initiated for the said market. Next, nonetheless, this order would not prejudice the petitioner to seek an early decision of the respondent authorities on the prayer for refund of rupees 4,75,000 for the year 2022-23. Next, accordingly, this interlocutory application stands disposed of. In the writ petition, you say.
We have sent the affidavit for getting man.
Okay, the writ petition say list on. We will be fixing it after 10 days.
Yes.
List on so and so. By which time the state respondent number
9th of June, my lord.
9th of
1, 2, 3, 6 and 7.
okay, 9th of June. 9th of June. List on by which time the state respondents would file their affidavit in opposition. Yes.
71 to 73.
Two or three matters have been upgraded. Those will be taken up. I don't know whether I'll have time for others.
Oh, my lord, we have another item 5051, that is about FPDCL, my lord. Contact date is my lord first today 3 matters
Okay.
came. 5051 of part 1, my lord.
Okay, what is this matter?
But you was kindly take a 72, my lord.
Of which rate petition?
Pre-petition, my lord. 70, item 72, my lord.
72, okay. Page?
Item 72, your lordship kindly see that is, we have filed a year also, my lord. And you will kindly see the last order, my lord. First order, my lord.
First order.
Yes. This makes clear everything, my lord. 6/2/23.
But Mr. Sorry,
My lord.
this issue of the areas we included in the ward, it's in the pure domain of the authorities. By your objection, you can't
So
change
we have
the.
done my lord, objection also, my lord, raised, and we have done objection as per section, my lord. And it was hard, but suddenly this without saying anything, my notification came. That 28, my lord, that notification dated.
It's a merely consultation process. They don't have to what you call adjudicate on that.
No, my lord.
Because it's a government decision to have it.
We have come that arbitrary decision, my lord. Because you have invited as per section 3, my lord, of this act, my lord.
Municipal Act.
Yes.
I have that.
New Corporation Act 2022.
I don't have that. Assam Municipal Corporation Act
No, I have already.
2000.
22, Assam Municipal Corporation. 2022.
No, we don't have that. No, I don't have that. Just give me a copy.
This statute says, my lord, if there is an objection, my lord, that to see whether people support or not, my lord. The section 3 or what kind of section 3 or not. Yes.
Where is the impugned order?
Important notification, my lord, Yes. MP notification is page 131. 28/11/22.
No, but you see this page 93, they have considered your objection.
Yes, 93, your page 93. Then your will find 98 kindly, my lord. Page 98 also 16/8/22. Page 98. Yes. That is objection was invited, my lord. Yes. Thereafter, your loss will find. Yes. Then page 108. Objections are invited.
The invitation was in the
108.
108.
Yeah, gadget notification was found. Under subsection 3(1).
10, this matter was only page 103, Annexure 7.
10.
The first writ petition you said, I am taking up that.
No, I am taking my second one, 72.
Oh, acha.
595.
595.
595.
$138.
Yeah, 108.
108.
Yes. That is notification date 28 September 22. Under section exercise of power under section 3(1) of this act, my lord.
Yes.
After minority considering the proposal received from the deputy commissioner for custody of municipal board is pleased to declare that the municipal corporation itself shall be constituted. The copy of the proposal that contains the proposed words so and so are kept in the office of the deputy commissioner and at the Silchar so and so.
Yes.
As provided under section 3(4), any inhabitant of the city, town, so and so is being published, ma'am. Objection within 15 days. Invited.
Yes.
So that was submitted. Then now 126 you will have it, page 126. Yes. 126. Now for 117 will be better. 117. Deputy Commissioner asked the CEO, my lord, to call on the matter. 117.
Yes.
In pursuance of the government notification, so and so proposal for constitution, notice so and so, been brought into public domain, made available at the notice board. CEO, official executive officers, also and so, proposal have also been published. Claims of this, if any, shall be received by so and so, additional deputy commissioner. Accordingly, your lordship will find page 126. We have filed to them, my lord, this objection, your lordship.
Yes.
In objection, then your loss will find 130.
Yes.
130 is again data from deputy commissioner. That is hereby entrusted to hear and scrutinize.
Yes.
Then your loss is page 131.
Yes. So they have heard it.
No,
46.
we were heard. My your loss entrusted to hear and scrutinize the claims and objections. Nothing mentioned here, my dear.
No, it is there.
Most majority of the people.
Page 131, whereas 46 numbers of claim and objection were received.
Yes.
Correct.
Yeah.
The claims, whereas deliberations and examination of the claims and objection, then they took a decision.
No, what is our resolution, my dear? Because they have invited the resolution, and what our resolution said, that is Gau Panchayat, that is village, my lord. At the instruction, my lord, this hearing took place, and the resolution was also forwarded. Resolution was forwarded by the Gau Panchayat secretary, my lord. That's one. 7. Oh, 70. Yes, 70, my lord. But once, my lord, you have invited from the public domain, my lord. Public has majority public are here, my lord. They are.
No, you see, Mr. Chaudhary, for that aspect, in India, every law which is enacted Before that, they are put in the public domain of the parliament or the assembly, saying that anybody has objection may file it. Correct.
Yeah.
But I have not seen in any act or notification or any law where there is a where in the aims and objects or in the introduction, there is a discussion of the objections.
Oh, it is not a mere formality, my lord. I think, my lord, because
It's
since
not a
Act
question of
has
formality.
provided,
No,
once Act has provided, my lord, because this area is to be incorporated in another area. So that area, Act itself say, get power to hear and to address to their my lord grievances. Now, page 76, my lord, what is the grievance of the people, my lord? They have taken a resolution. Majority of people attend the meeting. They have taken a resolution, my lord. You'll find it in page 76. English function of and vernacular is also there, my lord. Yes, on the basis of their my lord decision, Gaon Panchayat meeting was held.
no, I'm not saying, you see, those are not there, but the question of consideration would not mean a
Where is
consideration.
the my lord? Something must be there, my lord, because we have your logically what is our level? It is below poverty line, at 80% agriculturalist. Your whole intention is my lord, non-agriculturalist, my lord. Now whole 80% are agriculturalist, below poverty line. They are entitled to get PMJ, etc. So many even tax rebate also there in the villages, my lord. And it is that a specific case. Once we have got into the corporation, naturally tax will be double. Other things will be deprived of getting all the benefits which are normally available to the panchayat, my lord. Nothing will happen. This is specifically, it was mentioned here, page 76, my lord, in the meeting itself. Now, it is not a mere formality, my lord. Once the Act has provided to hear the public, at least you say, yes, whatever they have stated is not correct, or it is not based on fact.
No, it says that the whereas after detailed deliberations and examination of the claims and objections, government is pleased to dispose of the petition by
My lord,
rejecting
whether
the
that has
claim.
been done, that is why your lordship is here, my lord. Whether it has been done or not, my lord. On the face of it, my lord. You must have some
No,
deliberation, you say something, my
No,
lord.
you see, you show me any decision or anything where
Yes.
where it has been held that the governor must express his what you call adjudicatory opinion. That is not required.
Once Act says, my lord, Acts 3.1 and 3.4, my lord. So you have to go through that by the procedures.
But
Once you
adjudicated process is not there. He'll have to not give
but
a.
the process cannot be arbitrary, but it must be then what is the purpose of the legislature, my lord? This it is passed by the legislature, my lord. Some the intention must be there, madam. Why you are bringing the public domain? You have to hear public grievances. What is the grievances, madam? You are saying that, madam, it is non-agriculturalist. This is 80% agriculturalist people, madam. Your lordship kindly see their whole section 3 of the kindly section 3.1. Exclusion, my lord. Power is there, exclusion also power is there. Yes, but legislative intention is very clear, my lord. Yes, you have a power to include, power to exclude, you can do it. And just hearing to put it in terms of their letter, they have asked you hold a meeting. There's something, some meaning is there, my lord. The deputy governor asked them to hold a meeting of the people, my lord. Accordingly, meeting was held. In the meeting, majority decision was that, my lord, we are not interested to be included. Where is the finding of that, my lord, in the MP notification? Let them come up with the records, my lord, what is the deliberation? The MP, they have taken after deliberation, after detailed deliberation, etc. These things as examination. What deliberations they have taken on the basis of the claims and objections, my lord?
It will not be there.
Must
There
be
may-
in
no,
the
no.
minute, must be
Because-
there, my lord.
No, you
But
see,
what they say, whereas 46 numbers of the claims and objections are received from various individuals and organizations to the deputy commissioner, along with a specific observation of the deputy commissioner on the claims and objections. Whereas after detailed deliberation and examination of the claims and objections, this final notification is issued. From since February, it is pending. Nobody is coming up saying that yes, this is the case. Nobody is coming up. Take advantage of delay. They have now, they are proceeding with the election. Voter list. Today it has a date of publication. This court has got my right to see what the deliberation and examination taken on that.
I'll tell you why.
Yes. No,
I'll tell you why.
yes.
You see, when 243Q,
Yes.
243Q will say,
Q.
yes, it will
Yes.
say that the decision would be of the governor. Correct?
All functions are done by the.
No, it can't be done. This is something
Yeah.
which the governor has to do within the within the meaning of second part of clause 1 of Article 123. See 163, Article 163, clause 1 is the second part. It can't be delegated.
163.
Article 163.
If any question arises, whether a meta is or is not a meta as the governor is by order under this constitution required to act in his discretion, the decision of governor in his discretion shall be final. And the validity of anything done by the governor shall not be called in question on the ground that he ought or to have been acted in his discretion.
Second part. This is the second part.
Yeah.
So it can't be called in question.
So whether it has been done by governor, my lord.
That's recorded. That's what I am showing you time and again.
Yeah.
That is what I am trying to show you. You see, this page 132 of this brief you have showing me.
Yes.
First part says, whereas after detailed deliberation and examination of the claims and objection,
Right.
the governor of Assam is pleased to. If it was not governor, but it was somebody else, I would have struck it down.
My lord,
All the orders, governor
No,
does
no,
not
no,
know.
no. It said that you see, that's what I'm saying.
Yeah.
Like,
Based on business, final executive business and order that will say.
you see, that's what I'm showing you article, article,
163.
no. 243Q.
What is the key?
243Q says that it is him to be done. So
Right.
that can't be delegated, number one. If that is delegated, then it will be struck down.
Right.
Correct. The second part is 163, Article 163(1), second part, which says that it is his discretion and it can't be called into question. Therefore, when he has done the act, he has considered the objection, and whatever he does, it can't be called in question.
Whether that was done or not, my lord.
No, that is done. I'm showing you.
All the order, the rules of
No,
business.
I'm giving you time,
business-
Mr. Chaudhary, I'm giving you time, I'm not closing this read right now, I'm not dismissing it.
Right.
I'm giving you time because you have to do some research on that. You see, but I am very confident that once this governor passes an order, and it can be shown that it is under Article 163, 1 and second part of that, then it can't be questioned in a court. That is what I am on.
That's
That is
absolutely
one
right,
part.
Madam. You're absolutely right.
That is one part. So therefore, I'm giving you an opportunity. You just do that research because it will be a wonderful deliberation. Hardly we have these deliberations here. Correct. So
that, my lord, that records shall be called.
no,
That will show, my lord.
no,
Only
it
then, my
can't be,
lord.
no, it can't be called. If I can't question the order,
File is from the commissioner, man, not from the governor.
no, but
Order
this
is
is-
passed by the
no, you
commissioner.
see, no, that's what I'm saying, Mr. Chaudhary.
Yeah.
I have said, you see, a record of satisfaction,
Yes.
merely a record of satisfaction would be all. Because in the governor's file, you will not find anything more.
No, this file, madam, which is issued to the commissioner.
So
my
if
lord.
if it is of the governor, I can tell you, I can assure you, you will not find anything more than what is written here. He will just say, the governor, when he is exercising power under Article 163,
That, my lord,
will
yes.
merely say that I have recorded this satisfaction
Not
and
necessarily, my lord. We are not on that one.
Ah.
We are whether it is sent to governor with all this or not, my lord.
no, it is
They are
because
not- Because here says, my lord, your loss kindly say page 131. Whereas 46 numbers of the claims or objections were received from the various individual through the deputy commissioner along with a specific observation of the deputy commissioner.
whereas
On the
after
claims and objections.
yes, whereas after detailed deliberation and examination
Yes,
of claims and
examination of the
objections,
claims and objections.
ah,
Whereas the detailed deliberations and the examination of the claims and objection, the governor.
Ah.
So initially, this deputy commissioner, he has given his comment on the claims and
no, that
objections.
is how the file will move.
That is all, my lord. So that would show, my lord, that actually it was sent to governor, which is simple formality, my lord. Two things, my lord. One is discretion, once it go to the governor, exclusively he is to exercise his power. As
Yes.
far as my lord that is there.
Yes.
What your lordship is
Indicating.
in my mind. But here maybe that file is there, my lord, and nobody they exercise the power and that ultimately one of his power. Satisfaction. That's why file is required.
That can't be just.
What deliberations and what examination DC has sent.
No, that will not be recorded. I can assure you, Mr. Chaudhary.
My lord.
You also have the experience of dealing
No,
with the
that-
files of the
that might
governor.
have done, but normally business of what we find, madam, most of the cases that do not send it to government.
No, that won't
Even the
happen.
maxi petition we find.
No, that won't happen. It would never happen. It would never
Formality,
happen.
my lord.
No,
They may send, but
that I won't comment here. But the fact is that it never happens that when a satisfaction of a governor is required, the file will not go to him. That would never happen.
the file
it
may
will-
go,
it-
but ultimately it's simple, just my lord.
Just get
But
the
here
response
something
that has
file
been
must
sent to
say
the governor.
something, madam. What is the claims, what is the observation made by the deputy commissioner? It must be there in the file, my lord.
It's okay, but Mr. We don't need that file. We just want to know that whether it was sent to the governor, only that much. Because once you see, the problem is 163. Once it can be shown that it is a discretion which is exercised under 163, then the court, unless you show me an authority, that's why I'm not closing it. It will be, that's what I'm saying. It will be a wonderful. So that is why I'm not closing it because
No,
this
that's
would be a
what your
wonderful.
lordship- But actually, my your lordship is to know how it might happen. What is the,
It will definitely go.
what is the observation made by the deputy commissioner on the objections?
No, it will definitely go. That's what I'm showing you the sequence. You see,
I'm absolutely
you see, 243, why I'm showing you,
Yes, yes.
you is
Chief,
that it is the satisfaction of the governor is to be
That's
required.
true, man. That is
And
there.
that is a constitutional mandate.
Once it is done by governor,
as per 243, then of it cannot be.
163 comes in and therefore I can't.
Whether it was done or not, this is the question.
You get it? So I'm not closing it today. Had Mr. H.R. Chaudhary and senior counsel, assisted by Mr. F.U. Barbunyal and counsel for the petitioner. Also had Mr. K. Govil and the government advocate appearing for respondent numbers.
Also, I am for 1, 2, 3, 4.
Not
5.
already issued, my lord, already noticed.
No, not that. I have to record the presence. 1 to 4.
5 up to 5.
1 to 5 and then 7 also then.
7.
1 to 5 and 7. You will be appearing for? Sir, Mr. P. Handic for respondent number 6. Next,
Yes, which was a mistake of no.
having regard to the provisions of Article 243Q as well as Clause 1 of Article 163 of the Constitution of India, the court is inclined to ask the learned government advocate to obtain specific instructions as to whether the file relating to
130 or page 131.
relating to issuance of notification dated 28/11/2022 by the Commissioner and Secretary to the Government of Assam, Department of Housing and Urban Affairs, was or not placed before the placed before the Governor of Assam for his consideration. Next para, the learned government advocate shall send a downloaded copy of this order to enable him to obtain instructions. How much time? 2 weeks?
Only one of they are proceeding with that brutal list preparation, they are proceeding with the election.
Okay, so make it
That's
10
why
days
for-
then. Make it 10 days. 9th of June, 9/6/2023.
71, 72, 73.
Same.
All same.
I'm sending you this
My lord, can it be on 8 why not?
8th. No, 8th is a Thursday.
Okay.
It is better on other day because I have a lot of parted matters which.
Only mother, you will not be there, so I
Sorry? Okay, 8th.
obliged to us.
You take your book.
Yes, my lord. Yes.
74.
You keep it, we will take other one.
No.
Oh, no problem, my lord.
No. Mr. Chaudhary.
Not to your lordship, my lord, given to the.
No. Because I have, I don't, it is a habit from my small, when I was a kid. My father always insisted that I should read, purchase and read a book. Means I don't know why, but it is imbibed in my mind. Even now, I purchase books. I don't take what you call few books from the court and for my personal reading. 3 books, for example, every year I'll purchase in the month of January. It's a CRPC, IPC, and this Evidence Act and the CPC. These 4 books I'll purchase every year in the first week.
New edition.
New edition. Whenever it comes, because
This habit I was having, but I don't read, my lord. I purchase, I don't read.
that is only one reason can be ascribed. Because to God, some people get low memory like me.
Your
And,
lordship is very much,
God
my
may
lord.
have bestowed better memory to
junior
you.
is saying, my lord, we need not give a decision to his lordship. His lordship very much, with equipped with all the decisions. in his
No,
court.
because this is the advantage
My
of
junior is
this.
saying the other day, my lord, we need not
This is
spend
a-
money. My lord is already equipped with all the decisions.
No, because you see this, it is an advantage to
That's-
have
that's
a
why it is.
thing.
No, normally other code you don't find, but here it is fine. So that is what my junior is saying, man.
No,
We
because
should not spend money by getting it for the state.
no, it's
It is
not
there
required.
also.
It's not required. Because you see, there's another aspect.
Yes.
I'm, so far as I am concerned personally, I am miser when it comes to use of paper.
That's.
You see, what do you call this? Writing papers, I use both side. And what do you call, I also reuse papers. These are my all the type wastage, which I use for making a writing.
That's one very good, one very good.
There are two reasons for it. Number one, because ultimately we are dependent on trees. So if I misuse a paper, that is something which I don't do. I can't do, in fact.
I am trying to learn by the way, I could not hear my.
So therefore, this stoppage of printouts is only to prevent that. Since I have the documents, I can use it.
That can be avoided.
It can be avoided. So there's some, see, it's because of the bad habit of becoming a miser.
No.
Nothing more.
That is a we are trying, but I personally I could not file. I am even by learning my but I couldn't.
That then energy wastage. If I go out of my chamber, my AC will be off. It would not be on. By mistake, it may be on some day, but I don't keep it on. So these are few miserly habits I have.
No.
Doesn't I have?
Very good.
Yes, next.
That contact matter my APDCL. He might have came today.
We will take it up.
Number. So
APDCL, who is there?
item 50, 51, and 70, 75.
Just try to find out, Mr.
One
Patel.
order is already there, madam. You must kindly see the order that will do, madam.
Okay, just see Mr. KP Pathak or
APDCL,
APDCL, KP Pathak, anyone.
if possible, madam. Already.
Just wait for some time.
Madam, no.
Yes, item 74.
My lord,
May I
in this
please
matter,
read it?
lordship, I have
Yes.
seen one IA in the cause list, but no copy of the IA was served to me, my lord.
Which matter?
74.
Oh, acha.
Lord, they are praying for an implement, my lord. We do not have any objection as regards their implement as a shareholder.
No, who's filing for objection? You are filed. No, please give a copy, otherwise she will find it very difficult.
My lord.
It could not have been, in fact, filed
Lord,
without serving copy to her.
In fact, lordship, there are several matters pending regarding this issue. This honorable court has called an order, my lord.
No, it's
my
just
lord,
for
the-
impleading.
the
Today is
date
for impleading.
Implement,
We'll implead that, but you give a copy. No, just let me have it.
Lord,
Mr.
the-
Islam, give her a copy.
That's right.
I will say as Islam, the counsel for the applicant. And for the applicant and Mr. A.R. Bhuya Leonard, counsel for the opposite party number 1, and Ms. M.D. Bora Leonard, standing counsel for the cooperation department appearing for respondent opposite parties number 2, 3, and 4.
My lord.
Next para. The applicant has filed his interlocutory application for being implemented as respondent numbers 4 to 8 in the connected petition.
There is a mistake. 4 to 7 it should be put.
It should be 4 to 7. Okay, 4 to 7 in the connected petition. Stop. The Learned Standing Counsel for the Cooperation Department has raised an objection as copy of this interlocutory application was not served on her. So the Learned Counsel for the applicant shall serve copy of the interlocutory application to the Learned Standing Counsel for the opposite parties number 2, 3, and 4. Next para. Be that as it may, as the prayer made in this interlocutory application has not been objected to by the Learned Counsel for the opposite party number 1, public writ petitioner, this interlocutory application stands allowed, and the applicants are implemented as respondent numbers 4 to 7 in the connected.
4 to 7.
4 to 7 in the connected writ petition. Yes. In
My
the,
lord,
My
this
lord, in the
requisition may
main
be take
requisition,
along with
my lord.
WPC number 1504/2023.
yes.
My lord, that is correct. My respected friend is correct, my lord. But only difficulty is that, my lord, as per the tenure of the, my lord, board of directors from the date of last election, today is the last day. My lord, to operate our body, my lord. Now, the difficulty is that, my lord, we assume the charge in the year, my lord, 2020. And from that, my lord, this body is required to run up to 2025, my lord. 20th of May 2025. That is the issue has been raised in this petition, my lord, that pursuant to an interim order, my lord, passed by this honorable court, we have been, my lord, debarred from, my lord, taking over the charge, the board of directors for a period of 2 years. Now, subsequently, my lord, the petition was came to be dismissed, my lord. My lord may be pleased to find the order at page 21, my lord, 7/10/2020. And my lord, once the writ petition is dismissed, this, my lord, board of directors has assumed the charge, and till date, we are continued only for a period of 3 years, my lord. So, my lord, that's why we are
No, but
paying.
extension can't be allowed.
Yes, my lord.
Period is 3 years. It's a fixed
No,
tenure.
that is correct. As per the statutory provision, my lord, there is no provision for the extension. But, my lord, when there is an interference of this honorable court, my lord, in many cases, my lord, once the, my lord, such interferences is there, then my lord can always, my lord, extend the period, my lord, because this is an interference
No.
of this honorable court, my lord.
No, because that would be what you call defeating the legislative intent.
My lord.
My lord, my lord, in one of the cases, my lord, when the select list of a, my lord, statutory select list, my lord, was valid for a period of 1 year. Now that select list was kept in abeyance pursuant to an order, my lord, passed by this honorable court for a period of 3 years. After that expiry, my lord, that select list has been given effect to. Exactly, my lord, the same, my lord, analogy is also applied in my case also, my lord. Once the, my lord, it is a statutory prescription, my lord, no doubt, my lord, that it will run from election to, my lord, 5 years. But, my lord, once the, my lord, body has been debarred by this honorable court that it will not function or they cannot be taken, they assume the charge. And that period of 2 years, my lord, pursuant to an interim order passed by this honorable court, my lord. So, my lord, if my lord may be pleased to hear the issue, my lord, on that subject, my lord, can issue fix a short date, my lord, as the time is running out today, my lord. And till then, my lord, we may not be disturbed, my lord.
No, that order I'm not inclined to pass.
My lord.
I can't give you a protection which will defeat the purpose of the act.
My lord, may kindly appreciate the situation, my lord. This is some type of a situation, my lord, which has not perhaps occurred, my lord, earlier also.
No similar.
For some other reason, my lord, the COVID or my lord.
Proceed.
My lord, for some other reason, my lord, that the COVID period or something like that, the act has also been amended, my lord. But we are not saying that we are the victim of the COVID period, my lord. We are the victim of a petition which came to be frivolous, my lord. My lord, may kindly peruse the order of disposal, my lord, is at page 24, my lord. Page 24, my lord. Just for a moment, my lord. Initially, my lord, maybe peruse the page 18 of my petition, my lord, where the interim.
I'll tell you why. You see,
My lord.
the non-performance of any the non-functioning of any office because of the court
My lord.
is not saved under any law, even if there is a court injunction. You see, but there's a disability can be what you call condoned on specific grounds alone only. You see, if there is a legal disability, then we can understand. But still, you see, let us take an example, extreme example. You see, in a political scenario, this, let us say the state assembly or the parliament could not function because of vehement protest on every day when the parliament or the assembly was sitting. Correct. Now there was vehement protest. It couldn't be what you call these all these sessions, session 1, session 2, 4 sessions or special sessions could not be held for a year. Can the government come up and say that, well, we couldn't function, no laws were passed, nothing could be done, no appropriation. The state machinery had failed. So now we need an extension of the tenure.
That cannot be, my lord.
Yes.
But here is a case, here is my lordship is there, my lord. The power of my lordship under Article 226, my lord, from my limited knowledge is far wider than the, my lord, the decision of such a situation of the government. Now, my lord, here is a case with my respectful submission, my lord. May I kindly peruse the, my lord, interim order at page 18, my lord.
You come to the provision first.
My lord, provision is very clear, my lord. The, my lord, section 42, my lord, may be pleased to peruse, my lord.
Cooperative society, sir.
Term of director.
Oh, acha. This, okay.
My lord, section 42 says that the term of the directors, the tenure. You got it, my lord?
Just a minute. Yes.
My lord, the term of directors, the tenure of an office of elected member of the board and its office bearer shall be 5 years from the date of election, provided that the tenure of office bearer shall be coterminous with the tenure of the board. It is very clear, my lord, that the from the date of election, we can, my lord, continue for a period of 5 years. Now, section 33, my lord. Section 31, my lord, is also connected with the issue, my lord. The term of the board says that the term of the board shall be 5 cooperative years from the date of election of the directors. Now, my lord, the we had been elected, my lord, on 28.
Which section you are referring to? Which section you are referring to?
31, my lord.
My lord, section
31 and 42.
31.
Yes, my
My
lord.
The term of the board shall be 5
Shall
cooperative
be
year.
5 cooperative year, my lord, from the date of election of the directors. Now, we had been elected, my lord, on 29/5/2018. Now, my lord, once there is a proceeding has been initiated for, my lord, for holding the first meeting, that meeting was scheduled on 11/7/2018. And this writ petition was moved, my lord, at page 18. Page 18, my lord, the challenge was made to the first meeting of 11/7/2018, and this honorable court, my lord, in an interim observation, let the meeting be held on 11/7/2018 as scheduled, but approval of the same shall not be granted by the assistant registrar of the cooperative society, so and so, until further orders. So, my lord, this until further order.
Just a moment, I'm missing it. Which page you are
My lord, I
referring
am
to?
referring to page 18 of my writ petition.
Oh,
My lord, the last, before the last paragraph, my lord, is the operative part of the interim order. Let the meeting be held on. This was the first meeting, my lord, for the selection of the chairman and other members. 11/7/2018 as scheduled, but approval of the same shall not be granted by the assistant registrar of cooperative societies, Borpeta, until further orders. Now, my lord, these until further orders continue till the date of disposal of the writ petition. My lord, may be pleased to find the disposal order is at page 21, and the, my lord, a detailed order had been, my lord, passed, and this honorable court, my lord, accordingly came to the conclusion at page 24 in paragraph, my lord, 9 and 10. The petitioner is found to have suppressed material fact regarding the existence of clause 23 core of the bylaws of the so and so, which envisages the 15-member board. Hence, the court is constrained to hold that the petitioner has not come with clean hands, and as such, he is found not entitled to equitable relief under Article 226 of the Constitution of India. These two writ petitions fall on this count also. As a result of the discussion above, these two writ petition falls and the same is dismissed, however, leaving the parties to bear their own cost. So, my lord, once this petition, my lord, came to be dismissed, the interim order get vacated, and then only, my lord, we could function this board of directors, my lord, from the year 15/10/2020, my lord, we are functioning. So, my lord, my respectful submission is that, my lord, as there is a frivolous petition had been moved, and our 2 valuable years has been, my lord, taken away, and my lord has observed that this is a suppression of facts, this petition was moved.
You are operating since
15/10/2020, my lord.
2020.
My lord. So, my lord, our prayer is that at least we should get, my lord, this 2 years extension, as this 2 years has been, my lord, due to the interim order passed by my lord, my lord. So, this is a, my lord, a peculiar kind of case, my lord, wherein, my lord, 2 years has been, my lord, taken away. And we moved the Milord authority also by a representation before the government on 22/11/2022 seeking this extension as well as the register. But both the respondents, Milord, has cited.
Just tell me,
My lord, my lord,
just a query. Now see, in an election petition,
my lord.
5 years is the tenure.
Yes, yes,
After 4 hours, 9 months,
my lord.
the election petition gets allowed. And
My
the
lord, my lord.
and the election of the elected candidate
Set aside, my lord.
is set aside.
And the petitioner is seeking 5 years extension, my lord. That cannot be. My lord.
Okay.
My lord may take this matter along with the application number 1504/2023. Similar matter is pending. In that matter, we have filed our affidavit also.
Last example is dangerous.
We have heard it. Why should we keep it?
My
We'll
lord.
dispose it off.
Then my lord, if my lord is disposing it, my lord.
No,
there is-
you see, I'm in no hurry in disposing it.
My lord, my lord.
But if you want, we can dispose it off.
Yes, my lord.
That's what I'm saying.
In fact, lordship, I had received my instruction before your lordship, my lord. But
Okay. See,
My
it
lord,
is, ball is in your court. What do you want?
dispose.
My lord, if my lord is giving extension to us, my lord, then
The extension can be given, but issue can be kept alive.
that helpful.
Issue alive, patient dead.
Huh? Then my lord may
But you
dispose
can't
of-
say that options were not there.
My lord, then, my lord, if my lord may be pleased to give liberty, my lord, to the present batch of petitioners or the board of directors to participate in the election which is coming, my lord, because otherwise,
You're not debarred.
my lord, we will be, my lord, disqualified
Why?
because, my lord, huh? Today is the last date, my lord, as the election and AGM could not be, my lord, held under our, my lord, tenure, my lord.
No, I couldn't follow you. Please
Not
repeat
under the
again. Please be
provision-
clear.
Section.
Provision to Swana, sir. My lord, if we cannot, my lord, hold the election during our
Okay,
tenure.
that will permit them.
My lord,
This will be permitted.
my lord,
There will be no disability because he has approached the court.
my lord.
We'll give them time. How much time? 15 days? What is the notice period?
45 days,
Notice for this.
correction of voter list or something like that, my lord, maybe.
But lordship, regarding that, I have to take instruction whether they have hold their AGM or not. on
No,
time.
he's saying he's
No,
not
no.
done it.
Today is the last date, we could not hold the AGM election, so therefore, my lord, if we could not hold as per the provision of this Cooperative Societies Act, my lord.
That will not be a bar.
Bar, my lord.
That will not be a bar. Because he has approached the court.
My
For
lord.
that, he can't be penalized.
Hmm?
Okay, but let me pass orders. You'll get it.
My lord,
Uh,
time is running.
I'll try to, but I don't know whether I can complete it or not. I'll try to do it.
My lord.
If for some reason I can't complete the order, then I'll give a date for passing of orders.
My lord. My lord.
I'll try to do it today, otherwise.
My lord, then 45 days period may be given to us.
I'm not saying anything. I'm not
Yes.
giving any days. I'm just saying that it will not be a disqualification.
My lord. My lord.
Obliged,
And
lordship.
just get me that information. Liability to, supposing it is not done today,
My lord,
he's saying 45 days.
45 days.
But assuming it does not do, somebody else will do it.
My lord,
How much time do the authorities get?
yes. Normal tenure is what happened, my lord. Within 90 days, we have appoint our inspector to hold the AGM, my lord. And within 3 months.
You get 3 months time.
5 days time, I'll take the instruction, my lord.
Because if you otherwise get 3 months time
My
to
lord.
do it, and he says that it can be done in 45 days.
My lord, may grant me 5 minutes. I will get the
Ah,
instruction
Get
right
it, get
now.
it, get it,
Obliged, lordship.
get it. But there's a Chaudhry's matter that APTCL.
Before troubling my learned senior, my lord, I'll seek an apology, my lord. My colleague, Mr. B. Chaudhry, was interested in this matters. He has left the court. So, my lord, I seek accommodation for today. May the matter be listed tomorrow and similar matters are fixed tomorrow, my lord.
Tomorrow, I have great difficulties.
Or day after tomorrow, because I don't know whether the 3-4 corners of the petition I didn't go through, madam.
So he says that the last day is today,
No. First May.
1st May.
First June. Effective.
Tomorrow one matter is already fixed.
Yes,
So
already.
we'll try to hear that instead of listing this because tomorrow I have difficulties. Okay.
Because in this case already there is observation matter, internal matter will pass in the light of the order passed by other court, my lord. It
Yes,
was
okay.
already there, madam, in this case.
Okay, okay. So we are listing this on 2nd. This also 2nd will be
No,
over.
my
31st. Okay.
Day after
Okay,
tomorrow.
okay, day after
Day after.
tomorrow. Okay. The positive time matters could not be taken up today based on 31/5/2023. Okay. But just tell him that all these matters being fixed.
Well, I'll just
Item
convey.
50, 51, 75. Supply 75.
51, 75.
50, 51, supplemental 75. Today's list.
30, 31, 75.
50, 51, 75.
Or 50, 51, 75. Same models. Okay.
Numbers.
Any interim orders have to be extended? Please tell the court master.
Lordship, in item number 47, Lordship, there is some urgency. It's a tender matter with regard to supply of Napier slips in the agriculture department. Lordship, I'm praying for fixing the matter on 2nd, Lordship.
On Friday,
Ready?
my lord, I'm appealing for a petition in that matter. My lord, my learned friend wants it to be posted on Fridays, subject to your lordship convenience. If it can be taken up on Friday, I have no objections, my lord. And my lord, just a humble submission, my lord, pertaining to this.
This one, sir.
We have an interim order that may be continued, my lord. And one more humble submission, my lord. There are two connected matters, my lord, relating to the same subject matter on the issues that we have raised in the current petition. So if your lordship is pleased to fix the current matter with the two matters.
No, Lordship may take up the 47 item.
My lord will take up 47, of course, I have no objection, but there are two connected matters.
No,
One
same
separate-
orders will follow because you see.
My lord, but that has to be examined by my lords. That is the reason why I'm submitting, my lord, that kindly lordship may take up the two matters also connected with the current matter, my lord.
Okay, because you see what happens is that
My lord.
every day I have more than 60, 70 cases every
Yes,
day.
I could see the list, my lord.
Even on what you call on 2nd, I think I'll have how many more than 60 cases already listed. How many?
No, there are more by Ludo.
No, my calendar.
More by Ludo.
So there's a difficulty. Getting listed is a difficult task now.
Or can it be on Friday? Now on Tuesday, my lord, if it is.
No. Along with so-and-so will be.
My lord, I have 1732, my lord. Read petition number.
Lordship, those are relating to two another issues, Lordship. Those two matters that my learned friend is trying to get at. But this is completely different.
It will be heard independently. Just remind
That
me.
is the only
Yes,
reason I'm praying, my lord.
I leave it.
That is the only
It
reason
will
I'm
be,
praying, my lord.
what you call it will be taken up independently. Will not club
Independently,
it.
my lord. Correct,
Yes,
my lord.
Lord.
1732, my lord. Read petition number of 2023, my lord.
Okay.
I'm deeply obliged, my lord.
Lordship, may kindly have a look the Society Act for a moment.
Just tell me.
Lordship, in 40 section 41(2), my lord. 41(4), my lord, where a board fails to arrange for holding election of the director for delegates as the case may be before the expiry of the term of their offices in accordance with the act and bylaws, all directors shall cease to be directors on the expiry of the period as specified in section 42(1). So they will be disqualified, my lord. As
We
per,
will extend that because it can't be. Once he has approached the court.
but they have to take steps before expiry of their terms. They are well known. On 28/5, their term will
So
be
that's why
expired.
we'll extend that.
But they have not taken any decision for any holding of any AGM, my
Because
lord.
he's in court. He can't stand a disqualification just for being in court.
Yes.
Whatever rightly or wrongly has approached the court. So his non-performance is attributed because of the pendency of this writ petition.
But
We'll
they have
extend that
approached
time.
this honorable court only on the 3/5/2023, the last month. On 28/5, their term is over, my lord. Yesterday, their term is already over, my lord. But they have approached this honorable court on 3/5/2023.
So we don't take an offense of it because of the fact that he made a prayer for upgrading and taking it up. earlier also when the matter was listed 2 days back, he made a prayer that the matter should be heard. It's not that he's filed it and left it.
The Lordship may grant them some time to hold the
So this
AGM.
this is the second time you are praying. I'm making a prayer for upgrading and picking it up.
In fact, my lord, in a repetition 1505, my lord, there is a observation from this honorable court also. If Lordship may kindly have a look the order. I have.
What is that? Just tell me what is that? Give her the.
If any order passed in the meantime, pendency of the repetition is subject to the outcome of the repetition. Yes, I observed by this honorable court also.
So it's okay. That's why we are now proposing to extend that
lord.
disqualification.
Lord.
Will not be disqualified
And my
because of
lord
that.
was appropriate order, but I have.
Okay. Oh,
May I please, your lordship? My lord, with due apology, my lord, I beg to mention, my lord, item 76 order supply, my lord. This matter is connected with, my lord, item 56. 56 hearing matter, my lord, almost concluded. So, my lord, IA is filed for only correction, my lord. This matter may be taken.
which one?
Item 76 order matter supply.
What is the correction?
Correction is, my lord, only name and date of retirement of the, my lord, petitioner number 4. My lord, kindly see paragraph 3, my lord. Paragraph 3, page number, my lord, 9 and 10, my lord.
Okay, I heard Mr. M. Islam Counsel for the petitioner. And Mr. P. Handy, learned government advocate appearing for the respondents. Next para. This interrogatory application has been filed for the for allowing the petitioner number 4 to correct his name to Sri Krishna Krishna Mohan Mohan Chetri Chetry, which is wrongly shown as Sri Krishna Krishna Mohan Mohan Chetri Chetry, and to correct his retirement date which is wrongly shown as 21/4/1993 PO2 31/1/2017. It is submitted that the mistake was a typographical error. The petition is considered and allowed. Next para. Nonetheless, it may be mentioned that as the connected petition has already been heard and reserved for judgment, the formal correction of the cost title, of the petition can only be done when the matter is released. So accordingly, this interrogatory application stands allowed to the extent as indicated above.
As far as matters,
Because it can't be corrected. I can't send this file for correction. It is only to be done when I am releasing the matter. Then only.
items number 54 to 63, it was in the hearing list today, the Gaon Panchayat matter. The state under PNRD department would like to file written arguments, my lord, in this matter.
We gave you permission to do it today. You have done it.
We'll do it shortly, within a day, by tomorrow.
No, not by tomorrow. Give it today. Because tomorrow he will not be able to attach the file. It will go to my home. He won't be able to attach it. If you want to do it, you do it in course of the day. Give it to the court master. Not tomorrow, because tomorrow the file will not be opened and kept.
Yes, your lordship. With regard to item number 28,
See, this all those items.
54 to 63.
Argument is judgment reserved. Also is the duly represented, huh? Yes.
My lord, item 28, my lord, because I have to, my lord, correct the name and address of the respondent number 6, my lord. I was supposed to take steps, my lord, but in the meantime, he was transferred, my lord. So I may be allowed to correct the same in presence of the registry, my lord.
Address, his address is different.
My lord. In the meantime, he was transferred.
Okay. Item 28.
28.
Mr. A. Ali,
My lord.
Learned counsel for the petitioner, submits that during the pendency of this petition, the respondent number
6, my lord.
6 has been transferred,
My lord.
and he prays to permit him to provide the correct postal address of the petitioner by amending the cost title. First one, it is allowed. The necessary correction of the cost title may be done by the learned counsel for the petitioner in the presence of registrar within bracket judicial. First of the petitioner shall also, the learned counsel for the petitioner shall also make necessary correction in the cost title of the learned government advocates who are appearing in the matter. Make corrections in their copy also.
Deep knowledge.
May I please proceed? Proceeding to the IA matter, I am appearing for respondent number 6. Kindly my name may be available. Item
Correspondence,
76.
just give to the court master.
Proceed.
May please your lordship. Lordship, item number 36, 39, 40, lordship. Kindly date may be fixed, lordship. These are covered.
He'll do it. He'll do it. The court master will do it.
Lordship.
Just indicate to the court master.
My lord, 33 also.
Just give it to the court master. He'll have to make adjustments 1 or 2 days, but he'll do it. Correct?